try to go back in point of the time when this all these proceedings were initiated in this court and the 24 days, 27 days of hearing of the original review proceeding. I was wondering, I mean, sir, it will be a little emotive sharing with the court, but if Lord should pardon me, I was wondering whether having regard to the enormity of this tragedy, which is in a way unprecedented, as every court says that, many commentators talk about it, and one of the wonderful volumes Professor Bakshi had brought on valiant hymns and all gas tragedies. I was wondering whether I'd not been able to persuade the court to look at the dimensions of the case which have emerged over a period of time. Because I think in matters of human tragedy, it's very important probably to go beyond. That's how many cases are dealt with, to go beyond some of the conventional principles which may persuade the court to hold on for a minute and say, well, where am I going? And in what direction I'm supposed to go, in order that it doesn't open questions which may remain unanswered in other jurisdictions, other considerations. That's it was troubling me yesterday. I thought
I put to you, this was an opening of a case.
Yes.
Nobody doubts the enormity of the tragedy. Yet, if you see where compensation has been paid, there is some question mark, but there are some assessments on who at all were liable for this thing. Whether in terms of the human damage, the enormity was as was envisaged or lesser, because the more severe cases have been less than anticipated at times. But people suffered generally, undoubtedly. That's one aspect of the matter. But we are not. See, it's easy to get emotive. But that's something I think this side we are supposed to eschew. And eschew that and focus on what has to be done, because we don't have the privilege to play to the galleries. We have to proceed in accordance with certain norms of this thing. And as I said in the beginning, the whole issue is arising from the fact under what jurisdiction are we hearing? It's the whole thing. Would I have taken the same decision when I was settling it in one question, not open to us? Whether not having had a review and a curative, to what extent we now go? One is, of course, a question mark, which I flagged yesterday. You had to answer that you did not file a review. Can you come with a curative? Your answer, one answer, maybe don't look at so technically the issue, because again, it's a human tragedy issue. But every dispute, every tragedy has to have a closure at some stage of the other. And in the wisdom of the government, at that time, a closure was put to it. And these are not private parties who come under pressure and put closures to issues. I don't think that's something which can be attributed to the government of India. They put a closure to it. A review also came by some of the parties. That issue was also debated before this court. Now, can we keep opening some wounds which are there periodically? It's a question.
Yes, sir. I know that question is a very.
This is answer only to what you said just now. That it's not that we are not sensitive to what has happened, but when the apex court does something, there are always ramifications in terms of many other situations which arise. When exercising our jurisdiction, 142 and we are doing. 142 may be available in a particular scenario. We do it. We try to do in our own way. Sometimes we extend ourselves to do complete analysis by
one of the most potent principles with the court.
Very important, but yet to be used with caution.
Yes.
And they're more in the nature of social areas, etc. Can in a curative, I would put it like this: settlement taken place 19 years ago, review decided, no review by government, curative filed after 19 years, 34, 38 years down the line, do we exercise a curative jurisdiction? Because we feel that from the data which the government seeks to place on record, some of the aspects that payout should be more, should have been more. And considering also that they abided by the settlement what was arrived at, and the settlement has worked out far more favorably in some monetary aspects arising from fortuitous circumstance of the exchange rate having become different. And the government having not really at that time flagged some issues which they took upon their own responsibility to see how things can be better there.
Can we do it? Because yes, the government took in its wisdom many factors while settling. Immediate urgent aid to the people was one. And then somebody may argue that, well, the government could have given the urgent aid to the people itself and contested the matter to get a better claim. That's one possibility. Somebody may say, oh, you are talking about a different stage of time, 1984. 1980s, economic scenario was different for the country. So there are many, many aspects.
I understand.
From all this.
That's why I thought because
And,
these are rare moments in the history of a court when
also, and you are more conscious than defectors. How something we flagged yesterday, what signal does it send? When you are talking about sanctity of a settlement of a government in today's world of national trade, commerce, so many other aspects. And we will don't keep that aside. This is a tragedy, so don't look into from that perspective. I do recollect that the threshold, the government wanted to take instructions whether at all they are pushing for it or not. That is the first statement. That's why we deferred consideration because we wanted to take a conscious call. You've taken a conscious call to proceed with it. You are entitled to it. But
I would still urge the court because the very, as I said, very rare historical moments in the court's engagement with fundamental principles of doing justice for those access to justice is a value of great importance. And then arguments were drawn before both the courts that because of the act, we did not have an opportunity of getting a fair trial. The court said, the Union of India stepped into your shoes as a balanced patriot, and I'm sure that will take care of all the concerns and the interest. And oh yes, to a certain extent, this principle really worked. But the Union of India in 1992, I just give a certain piece of information, but I also tried to find out why. Question was put yesterday about the minor injuries case, a huge number. There's a reason why it happened like that. I'll place a letter which has come to me because I persisted information soliciting to the government, digging letters over a period of time. In fact, I spent a lot of time in finding out and to satisfy your lordship's concern that the amount that has been received has been expended in the proper way. I insisted that every expenditure should be shown to me and how it's been expended. I looked into all those aspects. I don't find anything disturbing me as far as that is concerned. In the review judgment, the Venkatachala says in the event the settlement has to be set aside, the undertaking given in the settlement that UCC will keep a $3 billion in the proceedings. So I just looked at the $3 billion value in 1992. It is 7,800 crores. And was to kept in Bhopal Court as of today, it will be 52,329 crores. And what are they talking about? 3,000 crores interest and the value and the exchange rate. What a pittance it is compared to 52,000 crores.
Therefore, on the one hand, by reason of a trial not having gone through, I'm looking at hypothetical. Therefore, it's a huge difference which would have made to the lives of these people. I look at every one of those children born with deformities, mothers bearing this unbearable burden over a period of time. So those in 1992, even the court was hearing those matters, those very agonizing pictures were shown to the court. Very difficult to go beyond those agony. Therefore, that's why my urge in this court is that some of those issues which may have a certain legal dimension offer certain saying impediments to travel beyond the conventional understanding and approach. But I would probably urge the court as they travel along with some of the judgments that I'd like to place. Some of the technical considerations. I'm just flagging some.
I tell you only one thing.
Yes.
Curative jurisdiction is created by Hura's case.
Yes.
The coordinate constitutional bench. Now, can we expand the scope of what is laid down in that judgment? Whether
Yeah.
coordinate bench can expand the scope and take it somewhere else.
I will probably place some submissions on that. Like for
So that
instance,
is
when all
something
these
basic. That
Islamia and all those cases came, your lordships and all the cases said we can explain a larger bench. Your lordship sitting on the constitution bench. And that is an equal coordinate bench.
See, these are,
I'm not going to say that.
they are also do these things are also quicksand. They're quicksand in some ways. You just keep expanding everything.
No, with the amount of responsibility as the officer of the court.
On the lighter side, normally the government is very reticent that the court should even expand it slightly. Today you are asking us to expand it beyond all horizons and say that
It all depends on the context. I'm looking at the
it depends on where you stand,
but
which side you stand.
settle. I receive it with the way it should be
I
received.
think we are also constrained. We are constrained by many factors.
We are only trying to point out those factors that can be only let a heart rule.
No, you're also right. Those factors are embedded in the history of the case. If they're embedded in the history of the case, I only say there is a need to come out of the embedment and then see if principles which can be fashioned so necessary for the
Some
discharge
reason
of this case.
to dig out and take out these embedded issues. That's the problem.
That's all endeavor. There are issues which are embedded in many such cases.
You have to show us. See, we can't go on indeterminate hearing on this. You have to show to us, are there examples?
You are saying of such approach being adopted. Where? So, to inspire us to follow the path which you are wanting us to.
Your lordship, I know. That question I asked myself, and therefore the
So
need to look at.
here X court has in a given scenario, this is how it is traveled the path, and we are asking this court to travel that path.
Your Lordship is familiar with this maxim, if we just remember, pick up Bloom's legal maxims. And two important cases will be shown there. One is Ashby versus White, an election man. So if there is somebody has a right, the law will always find out a remedy, very broadly stated. You also find subsequently where there is no precedent. Men learned in law will retire to their chambers
And advise the king that lest the king has not done justice to his citizens. That's how the maxim has been applied. You will retire, man learned in law will retire to their chambers. Therefore, if there is no precedent, if a lack of precedent is the reason why sometimes the court may hesitate, then the entirety of common law would have never found its way through. And the constitutional law today, in some other circumstance, I said, we look at the expansion of judicial power and the literature on the judicial power in engaging fundamental rights and human rights, particularly. Books are written with the following title: Courts, Apex Courts, Constitutional Courts, Deliberative Courts, as mediators. So that's the kind of literature which should look at the evolving role of the courts as constitutional apex courts in very difficult, unforeseen, and lack of precedent circumstances. Otherwise, the growth of law will strike me. Roscoe Pound says, look at what? Your mechanical container. I'll just read out the passage. So therefore, we are looking at a situation which did not have an answer in 1992 fully and effectively. It did not. Kindly, I'll just read a few passages from paragraphs from the plane, then take off your lordships to the Hura judgment and see where possibly one can lead. So I am trying to share points of view which, if it receives the comment of the court, because probably as possible, we'll find a solution. I know that are difficult, but I only wish repeatedly that we may have to travel beyond those what called conventional technical objections, which can always be thrown around. And there are two documents to place on record. Good. You lost it, I'm sorry to place a letter for a losses like that. Yesterday, I'd asked this question, please let me know how this 3620 was, etc. Let me read it, Your Lordship, for me to read. This is the letter dated 25th of September 2010. During the course of the meeting of the group of ministers on Bhopal gas leak disaster, you directed that a brief note be submitted the long pending issue regarding the inclusion of 20 wards of Bhopal that have been hitherto excluded from the category of gas affected area. The government of Madhya Pradesh and I personally have been persisting the demand for the last 25 years. Here is a recap of the developments in this context. In August 1985, a meeting was organized under the chairmanship of so-and-so, where it was finalized that 30 wards would be taken up as gas affected. Minutes enclosed. In December 1985, 6 more wards were added to the list of gas affected wards, and the total number that went up to 36. Once this was communicated to the state government, to the center, all provisions and decisions regarding compensation, relief, and rehabilitation have been restricted to 36 wards. A map of the gas affected 36 wards is enclosed in Annexure 3. In all fairness, this does not appear to be scientifically accurate. But the historical error was communicated to the government of India. It remained in force for the last 25 years. Now, is it an issue for the government of group of ministers to decide as to whether this historical error needs to be corrected or not? This issue has come before the government of India on several occasions in the past. It began with the Union Minister for Human Resources, so-and-so, then Prime Minister in July 1991, requesting the entire city of Bhopal be included for compensation, relief, and rehabilitation. In his letter, he wrote, the intensity of the Bhopal gas tragedy cannot really be confined to the artificial boundaries of municipal laws, and we owe it to the affected people of Bhopal that the interim relief is made available to all those affected by the tragedy. In view of the persistent demand from the government of Madhya Pradesh, the matter was taken up for a meeting on so-and-so in 2005, where the chairman directed the state government should provide detailed data in respect to the 20 wards. So the proposal was put before the Honorable Prime Minister for consideration. In response to the directive, the state government wrote to the central government, reiterating its earlier stance and providing data regarding the funds that will be required for providing relief to the residents of these wards. It must be mentioned, the Welfare Commissioner used a dual formula for determining the eligibility for compensation. In 36 wards, the mere presence in the fateful night is enough. While for the remaining 20 wards, the applicant had to support his claim with medical records. The letter clarified so-and-so claims filed in these 20 wards, as many as 3 lakhs were rejected. The letter also stated in case all the applicants are considered genuine and provided a token compensation at the rate of rupees 25,000, a total amount of rupees 763 crores would be needed. This calculation was based on the assumption that in the 36 wards which declared as gas affecting every resident, regardless of the degree of injury, was provided a minimum of rupees 25,000. The matter was taken up once again in so-and-so in 2008, and the demand to include the 20 wards in the gas affected category was not agreed to. However, directed, the affected population, 20 wards, may take medical assistance in the hospital run by the state government. In the 36 gas affected wards, the state government may take appropriate decision in the matter. The minutes are so enclosed. As for the latest data received from the Welfare Commissioner, a total of 3,96,92 applications made for claims from these 20 wards, and a total of 5,283 applications accepted only of those who could present records of medical treatment. The remaining zones applicants rejected. The ward-wise details so. So that is, and then in the last page, it's a fact that detailed mortality and morbidity surveys are a complete medical record of the population of 20 wards do not exist. These were not collected over the last 25 years. So that is one great loss. Something which could not happen. So why I want you to play this data?
You're absolutely right. Therefore, it says Government of India, that's how.
I understand.
You acted on a premise for a quarter of a century. Now you say you should have acted differently. If you wanted to act differently, you still can make available wherever compensation more you want to give. But you are trying to parcel it on the other side today. The problem is nobody prohibits the Government of India from taking a more proactive approach and say, look, we feel that the people must get so much more. Do it. Nobody stops it. Can you fix it on them?
I could see that, but why I want to place a letter to just clarify certain lingering doubts which had come, and then how.
No,
and then
if you see the number of compensation, how many cases have been rejected? Do we take it that you wrongly rejected all
That's another aspect of the matter. Another aspect of the matter. I only want to put it to your lordship.
So Tony, there are difficulties in accepting this letter. This is a letter, a perspective of a particular person. Whether it was acted upon, what was the decision taken? Because it certainly says, as far as 36 wards are concerned, mayor presence is enough. So that was the criteria adopted. Mayor presence is itself enough. 20 wards, certainly no compensation. And neither it's your claim that for 20 wards in this curative petition, that compensation should be paid. That too after 40 years. That's not your case. I don't think that's the case.
I'm not traveling beyond. I'm not traveling
Yes,
beyond.
that's not your case. That this letter probably reflects the point of view of the elected members of the person who's also probably
I
a
only
minister.
wanted to place this letter.
That's fine. That's fine.
There's a certain reason that.
Attorney, what was the decision taken on this letter?
No, we stand committed by the curative petition claims, and that we are not.
I'm just saying, you have placed this letter. Now, what
Only
is the
to show
decision
that.
in that stage, what is the decision taken? Are we going to, how do we reopen everything?
No, I'm not asking
The
the
decision-making process, we say, no, because different dispensations remained in power at different points of time. Everybody had his own perspective, how this issue was to be addressed, this tragedy was to be addressed.
For a very limited purpose, I place this letter only to show that the concerns of the state government and the central government for a long period of time about how do we really address this question in order that a person who may have a just claim is not arbitrarily
As on
excluded.
2010,
That was the concern which
as
is
on
behind this
2000
letter.
As on 2010, this concern never found favor.
No, that's a different issue.
I'm not trying to favor
please
20
look-
years after that, nor after that
No,
never found favor.
please look at the concern underlying this letter.
So
Whatever might have happened,
we take it that Government of India did not act upon this request.
no, that the curative petition came to file.
No.
In the wake of this, the
Mr. Tony, let's be very clear. This letter is for the other 20 wards which were not covered. And I do not think it's the stand of the government of India that subsequently
No,
after 2010, those 20 wards are also covered. And that too after 2000.
I clarified that. The paragraph where the letter says in 1985, 36 or 30 plus 6 wards, the mayor presence, etc., were the criteria adopted. Only to clarify that position, because your lordship put me the issue about those minor injuries, how it became so, and all that. It's by application of this criteria that
No,
minor
you have
injuries
actually-
number came to the.
Actually, mere presence was given benefit irrespective of any injury over large areas. Nobody doubts that the right to give that compensation.
No.
So tomorrow you may say, well, that air traveled much more beyond Bhopal also. We would like to give a peripheral area also benefit.
There are two dimensions.
There must be a directness to the thing to fasten the liability of the tort fees.
There are two dimensions here. When the mere presence for a certain number of others who have been subjected to other kind of medical disability, like permanent disability, partial, all that have been gone through. This letter says 36 wards, but wards were so severely affected by the gas leak. So how do we now draw an artificial line between municipal wards? How did the gas leak travel and ended up 36 wards? That was the concern behind
What I'm
it.
saying, so the
Therefore, just give it in. That's all I want to say.
The Honorable Minister talks about Bhopal as a whole place, give everybody.
That could be
Then that may have gone. Then somebody may say, well, we should not have confined it to Bhopal alone. We should have traced
Yeah,
out where the air went.
That's right.
Therefore, all that.
I'm not getting into the larger question. I only want to say,
And in fact, going by your arguments, government should have granted the relief. Central government was not prohibited from doing that at that time. They could have granted relief at that time. On the
provided.
basis of this.
All the state government then in power should have
No,
used funds to provide
In
relief.
the government of India, I'm just asking.
I'm saying that
I'm sorry,
there were different dispensations and power at that stage.
I would only turn the court. That issue, all
So
those
there are different
issues are
dispensation, everybody writes according to what their view is. When you are in power, you are not in power.
My only reason for writing letter is for a very limited purpose. I'm not entering the question whether what government of India should have done at point of time is not really something which is being canvassed here. What I'm trying to say is in 85, if the government took a stand that 36 wards will be treated as wards for the purpose of whether we are present or other injuries, that's the only limited purpose I want to place the letter. Now, whether what government should have done or not is not what I'm trying to enter into a debate with great
There will
respect.
always be historical analysis of things even after 100 years. Question is, that is analysis, what ought to have been done, could have been done, perspectives, not what we are.
Yeah, they may not necessarily enter into the ultimate decision which the lordships make, but I just want to flag it saying that if there is a question which has remained unanswered, I said yes, this is how it has happened. To that limited purpose. So kindly, I will probably tell you lordships that
The curative petition is, I'll hand over two sets of notes. One, a note prepared by our friend Divanji, and I've also prepared a detailed set of submissions. God's permission, I'll try to read.
But before I do that, we read yesterday the judgment of the court of May 18, 19. We may like to revisit the judgment. And then the Hura judgment, etc. Before I do that, will Lordships pick up volume 1 of the respondent's compilation, a few paragraphs from my plane, the Union of India's plane.
Yes, what page?
The plane begins at page 216A and paragraph 8 at page 216C.
Yes.
Additionally,
Give me that compilation.
paragraph 8. Additionally, or in the alternative, the plaintiff Union of India brings his action as parens patriae by virtue of the legal. I'm sorry,
216C.
page 216C.
The plane starts with 16A, and you are referring paragraph 8.
Yeah, I am reading at page 216C, paragraph 8. Additionally, or in the alternative, the plaintiff Union of India brings his action as parens patriae by virtue of his interest and duty to secure the health and well-being, physical and economic, of all victims in disaster, including future generations of victims, almost all of whom physically and financially or otherwise incapable of individually litigating their claims against the defendant, a monolithic multinational corporation. Further acts as parens patriae by virtue of the interest and duty to protect, preserve, and restore the earth, air, waters, and the economy of the Republic. Further acts as parens patriae in exercise of the rights and duties under the said Act. Union of India is filing the suit as parens patriae for all persons to recover for them damages for all claims in respect of deaths, personal injuries, individual, loss of property, including death and injury of animals owned by so-and-so, business losses, damage to the environment, and other losses present in future arising from the Bhopal disaster. They also filed this suit to recover damages for expenditures incurred and be incurred by the government of Madhya Pradesh and by instrumentalities of the state for aid and relief arising from and caused by the Bhopal disaster, but not limited to ex gratia payments for death and injuries together with the medical treatment, rehabilitation, and food for the injured. Then, subpara 3 of that, the expenditure by the plaintiff, the state of Madhya Pradesh, and state instrumental either continuing in process, and the plaintiff leave to furnish further details of expenditure at the appropriate time, or the expenditure so far incurred is so and so. Now, kindly turn to paragraph page 216W. Between pages 216D and 216B, it captures the correspondence between Union of India and Union Carbide in regard to setting up the plan over a period of time. I'll also place Lordship's kind consideration, couple of communications which say how a very vital information regarding the deadly effects of MIC, a mere exposure, sufficient to cause huge implications for any person. That document is now placed under guard. So therefore, something like a delictuous conduct is unpardonable. We use that word. Now taking certain legal technicalities and shelter to say look here, over a period of time, I have had a shelter under the settlement and don't put your hands into it at all. Now, can you turn to 216W? Paragraph 18.
Yes.
Is what the union took as a stand. Multinational corporation, by virtue of their global purpose, structure, organization, technology, finances, and resources, have it within their power to make decisions and take action that can result in industrial disasters of catastrophic proportion and magnitude, particularly with respect to those activities of the multinationals which are ultra hazardous and inherently dangerous. Key management personnel of multinationals exercise a closely held power which is neither restricted by national boundary nor effectively controlled by international law. The complex corporate structure of the multinationals with networks of subsidiaries and divisions makes it exceedingly difficult and even impossible to pinpoint responsibility for the damage caused by the enterprise to distinct corporate units or individuals. In reality, there is but one entity, the monolithic multinational, which is responsible for the design, development, and dissemination of information and technology worldwide, acting through a neatly designed network of interlocking directors, common operating system, global distribution and marketing systems, financial and other controls. Even today, UCC is selling its products all over the world, including India. So persons harmed by the acts of multinational corporations are not in position to isolate which unit of the enterprise caused the harm. It is evident that a multinational enterprise that caused the harm is liable for such harm. So has to bear the responsibility for it alone. And at all material time, the means to know and guard against hazards likely to be caused by the operation of the said plant designed and installed or caused by and to provide warnings of potential hazard. Inherent duty of the defendant is to exercise reasonable and effective means to promote safety and assure so and so. Now, kindly turn over to the next page, 216Y, paragraph 21. The defendant was in breach of this primary, absolute, and non-delegable duty with the undertaking of the ultra hazardous and inherently dangerous activity causing widespread risk at his plant in Bhopal and the resultant escape of a lethal gas from MIC storage tank at the plant, which he should have foreseen and prevented. Defend Union of India Defend Union Carbide further failed to provide the required standard of safety to Bhopal plant and failed to inform the Union of India and its people of the danger therein. Defend Union Carbide is primarily and absolutely liable for damages caused continued by the escape of lethal gas.
I don't want to obstruct
UCC was an absolute.
Your flow, but you must understand what is this going through, because nobody doubts that there is a liability, there was a liability on the other side. These are aspects to say, don't ask us to pinpoint which officer of the corporation or who is responsible. Monolithic entity is responsible. It is responsible, it is settled. All these paragraphs are trying to deal with a scenario where they may try to say that, well, X is responsible, Y is responsible, we are not responsible. In nobody's case, they are not responsible.
No. This doesn't talk about that. It talks about one entity which will be responsible as absolute liability and non-delegable duty, there being a breach of it. Therefore, in paragraph 21(2), the plaintiff is talking about the absolute and so non-delegable duty, regardless of fault, to prevent so and so. You require design. So therefore, this was an argument to say there is an absolute liability on the part of UCC.
No doubt.
I just want to flag it.
They accept that, and that is why they have to pay. Issue is, you pay more. That's all. We are not concerned that they are not liable to pay. That's not the issue.
Please, Mr. Attorney, just one question. One question.
I'm sorry.
All these facts, a word in the play, consciously, when it came before, in interim order, it came before this court, where this decision was taken, that this much amount to the extent be paid on the basis of all these facts. Then the review came to be filed, decided in 1991. After deciding, these facts were on record at the 11th point of time. After deciding that review, unlike the government has not come in a curative, and now in a curative after 19 years. So now the relevance of these facts or reconsideration in a curative made by a government is an issue here which we are discussing.
Your Lordship, please.
So these points were there at the 11th point of time when the decision was taken on 470 pounds. So these facts were there. We are not denying that this tragedy was there.
Why I want to go back to it? Only to say that the framework for a larger framework which needs to be presented to the court and connecting the dots. I'm trying to connect the dots. Every dot is relevant. In the sense that we're going back in the year 1991 or 89. But after 18 and 91, more dots have occurred. They were merged. How do I really connect them? Therefore, for the purpose of connecting the dots, I'm trying to say these are the pleadings, and the pleadings were certainly the knowledge of the court, and they were canvassed in a reasonably way before the courts. But regardless of those facts being before the court, on a certain assumption, that's why the order in May 1899 says, on a certain assumption, we are endorsing the settlement. We are all trying to say the assumptions are no longer valid and relevant and final. So assumptions have gone.
See, the whole problem, the moment you say those assumptions are not valid, are you opening the whole thing?
I'll come back to it.
You
Of
can't
course,
say
in a manner of speaking.
it's not, we are going again, I'm sorry, round and round and round.
I'm sorry.
Because the point is you are saying, well, we did settle at a particular value. We did take those monies at a particular value. Now, their argument is, are you opening the whole thing? You say rightly, no, we are not opening the whole thing. We are saying you are liable. You accepted liability, accept more liability. If the willing, there was no problem. But they are saying, no, this is the end of our liability because both sides choose to bring the liability to an end. Given that scenario, and as you put it in the plaint, looking to all future scenarios also. You are conscious that you are, as per the plaint, looking to all future scenarios, putting all those future scenarios to an end by entering into a settlement. And you chose to enter in settlement, not under any duress, not under any pressure. That's nobody's case, can't be, with the mighty Union of India at the one end. Therefore,
Why? I know there's a certain element of repetitiveness about it.
no, it's not repetition. I'm
But,
just saying that we will ultimately, at a curative level, what this claim
I'll come back to it. I'll
said.
immediately come.
I honestly don't think this is all relevant. So what we have to come to is, you are telling us that there is some very innovative path which this court must follow, despite the curative defined contours. Please show us somewhere where it has been done. Then only can we appreciate it.
I'll do
Where
that.
has it been done?
I'll immediately do that. I'll take the losses to the Hurrah judgment. Before that, there are some passages from the Regli judgment. I'll try to read that out and then go into the Hurrah issue. Well, I thought some of this little.
So what you're propounding is that the matter was left at that stage based upon the facts and figures,
Yes.
and it was open to the parties to move in accordance with law in case those facts and figures changed.
Yes.
That's your best argument you can.
Yes.
That's therefore you're not saying that the settlement should be revoked. You say please enhance the sum in the settlement.
That's right. I started with the proposition.
We have
Right.
understood that, but the difficulty which comes about is that the facts and figures are virtually known to you at that time. And number one. Number two, if the facts and figures subsequently set out in the affidavit filed by you in response later on when the dispersal of the additional amount is also made, is indicative that as far as serious cases is concerned, they have been adequately and fairly compensated. That you're not disputing. They have been adequately and fairly compensated. The real difficulty which is coming up is those cases which were classified by you in minor injuries. There again, they have been compensated, but the formula which you're trying to apply is whatever was paid, that should be kept static at that point of time, where the number of people specified in the order, which is not correct for the simple reason that even the persons who had died, of course, that number increased, but the number of people who had permanent disability decreased, number of people who had temporary disabilities also, there was a slight increase. But as far as number of pieces, at most severe cases, there was a decrease. So there has been some increase and decrease. So that was always inbuilt into it. The real issue, really what has happened is this 955 crores. And to say then the formula which you are adopting, there can be hundreds of other formulas to justify that there's no increase required. Because ultimately, the fact of the matter is, they have been not only compensated in death cases by 10, but probably 20 lakhs. That's a fact.
Right. But I was trying to point out, because
And
what is
let me
something
add,
lost
your
about this
plain reading shows that you had the present in mind, you had the future in mind, you had unknown possibilities of future in mind when you framed the claim. Therefore, when you settle with all those possibilities, all those known unknown quantities, known unknown possibilities, instead this is where we put to it. So the fact that you have a more comprehensive claim drawn up, looking to all and absolute, all possible scenarios, shows your settlement is not that something.
I may
call
only
it.
say-
May I say this? It creates a
May-
greater difficulty
May-
in your way.
May I say,
Because the plaint is very, very widely worded, very
and rightly so.
absolutely. But then the answer would be rightly so to settle it.
May I say
somewhere
that?
else.
And therefore we said,
In
if you feel that they are entitled to be paid more, please pay them. There's no difficulty. Question is what we should do in curative petition.
I just come.
If-
Why
If
am
they
I
are
among this
entitled,
foundation?
if they are entitled to more,
Yeah.
as paragraph 198 says, please pay them. Question is what we should do in curative. That's the only
Before-
question. Pay them. That will be most welcome thing to do.
No,
Pay them.
before your lordships ask this question, there are some of the questions are raised and answered in the review. And say, read them, this question probably
Yeah,
will come. I was responding to
See,
the
if
lordship.
you were as a welfare society so concerned you wanted to pay more, you should have paid more. It's not a question you paid more.
If the Union of India was the delict, all these questions would have been
No,
answered
no,
against Union of India.
No.
With somebody else in the delict.
Absolutely no. Absolutely no. You as a welfare state adopt a different principle whatsoever, whether
Oh,
you
yeah.
are liable or not.
You're also putting to me a question.
No, I'm
Maybe.
saying, is it that I don't want to pay, but I think I can get it from you? This is what
It's not a
coming
question.
to.
It's not a question of why I want to pay or what not to pay. The question is who should bear the liability to pay.
Have you paid?
Therefore, I said UCC is the liability to pay.
Have you paid that
Unless
extra?
that question, I'm so sorry.
Have you
unless-
paid that extra?
I know that question.
You
will be
want to
answered.
absolve yourself of a welfare state principle and say, no, I want to take it from them. As and when, if and when I take it from them, I'll pay.
So we have
What
paid
is
in
happening?
2010 ex gratia. We have done that to the extent that government of India should discharge their responsibility. So the welfare state coming in is an entirely different direction. Wholly unconnected to the question of UCC's liability. I would very humbly urge that question ought not to be linked with the question of the welfare state's intervention to undo the miseries of the victims. That's an entirely different link altogether. So then, why I was trying to bring this is in a very ordinary court. Was put to me why you had put it very widely in the plain.
What is pointed
When
out?
we put it in the plain, and I'm sorry.
No, no,
I'm so sorry.
Sorry. You see what the ex gratia amount you certainly paid. There's no doubt about it. But the ex gratia, the amount deposited because of various fortune circumstances, maybe depreciation, value of the P or interest thereon, was sufficient to meet that. What you have paid is 740 crores. You paid 740 crores, and the amount and figure which was ultimately available, was about 3,000 crores with interest and the depreciation value of rupee. So that was sufficient because what you have actually paid, let's be very clear. What you've actually paid is, even if we take the three figures together, that is 525, 675 and 740, it will still not. In fact, what you have paid is 675 and 725 and 740, which means about 1,500 odd, and you have paid 1,509 again. So you have compensated them. Yes, we have to account for that because if the figures were fixed right in the beginning, you have to
Yes.
account for the interest part.
Yes.
You have to account for the interest part. Unfortunately, the payment was not made accounting for the interest part.
No, that's why it told us yesterday. It relates to 1 lakh people.
Whatever you had, you paid. Whatever was due, you paid. Whatever more money was available, so you paid. Now, fortuitously, even after making payment, all those amounts, 50 crores is lying. That's what is the ground reality.
No, but may not be fortuitously.
So, fortuitous
Kindly, in the same law,
fortuitous circumstance in terms of, suppose the dollar rate had declined. different scenario would have
I would very humbly urge of your lordship. That's why I place this figure of 3 billion, which they ought to have brought to this court, and it will be 52,000 crores. Don't please look at 3,000 crores exchange
Why?
rate
How can-
because
How can we not look at it?
because
How can we not look at it?
rupee
You settled for it. We did not settle for it. You settled for it.
rupee devaluation. Who could have controlled it?
Absolutely. Therefore, when I use fortuitous, you say no. It is a fortuitous circumstance that the amount which was lesser grew because of devaluation of the rupee.
Even if I take it like that, it's a, in a manner of speaking, please don't look at the windfall gain for the victims. It is something, a pittance which they have got now.
It's not a win. See, we
Therefore,
are going
it's a
here,
windfall.
Ravi.
It is not
It's not
something
it's not
which
a question of windfall gain.
Yes.
It's not a gain for the victim. It is giving you a larger corpus by reason of this scenario to satisfy claims of the claimants. That's what has happened.
Right, you
Because
can't
in Indian rupees, that amount has grown larger. Therefore, you are in a better position to satisfy claims. Otherwise, the 1,500 extra would not have been there.
No,
Then you would have been settling for 1,500 crore.
The Union of India could have simply asked this question. I had a larger corpus on my hand by reason of all the intervening events and circumstances. Therefore, why should I look into the need for an additional compensation? Why should I look into that need? The need arises because the number and the assumptions have gone wrong.
Attorney,
That is the need.
we are conscious of that fact. We have all the sympathies for those who have suffered. If they need be, they should be paid more. Ultimately, you have to fit in the conspicuous of curative petition.
I'll come to that.
Within 4 corners of Pura
I'll
judgment.
immediately
That's
come
what we are repeatedly telling you.
I'll immediately come to that. But these are some
I
broad.
began by saying the Maryada of the jurisdiction. And I stick by that. And you accepted that. Every jurisdiction, we are not somewhere.
Is there
We cannot be please understand, the courts can't be, I always said, a knight in a shining armor, moving around and finding Parecia for all the things. Not possible. We are constrained by law, have some leeway.
Of course, you'll also constrained by law.
Of course, we have certain leeways.
But
And that also as the apex court we have it. But we can't say that we will decide a curative petition on the basis of jurisdiction of a original suit. Mine is any evidence.
Is the Union of India asking the lordships to enter into the curative engagement on any
Like a suit.
abstract proposition?
I'm being very, very frank. You are asking us to try a curative petition like a suit.
No, certainly. We have, not certainly, with great respect. Well, that could be one possible perspective, but with great respect.
Certainly, we will not do it. You do
No,
whatever you want.
No,
You can't make us do say we are in a curative petition. Now we'll produce documents. We'll do this. Please convert this into a civil suit.
No,
Yes.
what have I?
And
What have
reopen the settlement. Keep that settlement bits of their side on, and try the suit now. Carry on the whole trial of the suit here.
No. There's no.
What is happening effectively? Attorney?
With great respect.
This is the net result is this only. There's nothing else in this.
It may, in terms of form, it may look like that, but in substance, it is not.
What
Because
else is it?
in substance, it is not. So if the curative petition is based on the culmination of the welfare commission's determinations, and that's what was retained as inherent possibility both in the review judgment, because that kept it open. The review judgment kept this adjudicatory process open, and open for valid and good reasons. If that was kept open, and that has now emerged in a certain set of figures, I only ask you to look at when the review judgment came, you said, yay.
Let's come to the brass tacks. Let's turn to the judgment which you are wanting to say, and the curative where you draw strength. Let us turn to that. I think we have had enough of facts. We understand it. We are unwilling to. I've said so repeatedly. There's no point in our repeating it, and collectively we are unwilling to convert this curative into a suit. So please don't, which we believe is the path which is being traversed. Let us come to on what basis you seek to expand the curative duty.
Rashi, just now draw your attention to the review judgment, which is in volume 1.
Yes.
The judgment begins at page 60.
Deciding why doesn't he read the settlement order?
The settlement order. What is the settlement order? How do you open it? Please tell us.
In the same volume,
Yes.
I read out yesterday The settlement order is at page 41.
Yeah.
Having given our careful consideration for these several days, also including the pleading to the parties, the master data pledge before the material relating to the proceeding to the control courts of the United States, the offers and the counter offers given to the party, the different cases and so on. So as well as the complex issues of law and fact raised before us and the submissions made thereon, in particular, the enormity of human suffering occasioned with the Bhopal gas disaster and the pressing urgency to provide immediate and substantial relief to victims of the disaster. We are of the opinion the case is preeminently fit for an overall settlement between the parties, covering all litigation, claims, rights, and liability related to the arising out of the disaster. We hold it just and equitable, reasonable to pass the following order. We order the Union Carbide Corporation shall pay a sum of so and so to Union of India in full settlement of all claims, rights, and liabilities related to arising the Bhopal gas disaster. The aforesaid sum shall be paid to the Union Carbide Corporation on and so and so. To enable the effectuation of settlement, all civil proceedings relating to arising of the Bhopal gas disaster shall hereby is transferred to this court and shall stand included in terms of the settlement, and all criminal proceedings related to arising of the disaster shall stand quashed wherever they are pending. Memorandum shall be filed by us before us tomorrow, setting forth all the details of the settlement, enable consequential directions if we need to issue. And then the next page, order dated February 15. Having heard General Counsel and having taken into account the written memorandum, we make the following order dated so and so. So Union Carbide, already a party in numerous suits which have been stayed by an order dated so and so, is joined as a necessary party in order to effectuate the terms and conditions of our order dated. So, pursuant to the order, the payment to the sum of US dollars direct to the court to be paid will be made in the manner following. So these are then paragraph 3, upon full payment, paragraph 2, Union of India and Madhya Pradesh shall take all steps which will in future become necessary in order to implement and give effect to this order, including but not limited to ensuring that any suits, claims, or similar criminal complaints which may be filed in future against the corporation also are defended by them and disposed of in terms of this order. Any such suits, claims, and civil proceedings shall file so and so, or if they enjoined shall not be proceeded before the court except for dismissal of passing in terms of order. Upon full payment, court direction, the undertaking given by the Union Carbide Corporation was an order dated 13 November 1986 shall stand discharged, and all orders passed and revision thereof shall also stand discharged. Any action for contempt or party related to the case and everything of the proceeding in the court below shall be treated as law. The amounts payable by the Union of India, the orders shall be deposited to the credit registrar to bank in the next taken to the court. Then, in terms of the settlement, the parties will be taken in the court and form part of the order of the record. The case will be posted for reporting complaints on the first Tuesday of April 1989. Then comes the order at page 40.
So paragraph 3.
Please read consequential terms.
Correct. So the order at page 45.
No, we'll come to later. Please read the consequential terms at the bottom of page 43.
Parties acknowledge the order dated so and so and supplemented dispose of the entirety of all proceedings of number so and so. The settlement shall finally dispose of all present, future, past,
All past, present, and future claims.
cause of action and civil and criminal proceedings of any nature whatsoever, proceeding by all Indian citizens and all public and private entities with respect to all past, present, and future debts, personal injuries, health effects, compensation, losses, damages, and civil and criminal complaints of any nature whatsoever against the proceed. So all their subsidiaries and affiliates as well as each of their president, former director, officers, employers, agents, and so connected to the Bhopal gas leak disaster, including past, present, and future claims, cause of action proceeded against each other, all such claims and cause of action, whether within or outside India, citizens, so and so, hereby extinguished, including the limitation. Each of the claims
Please read this.
we claim so
Please read this a little slowly.
correct to be filed and any such proceeding.
Hereby extinguished, including without limitation, each of the claims filed to be under so and so, and
Or to be
all
filed.
such civil proceedings in India are hereby transferred to the court and are dismissed with prejudice, and all such criminal proceedings so and so. Number paragraph. Upon full payment in accordance with the court's direction undertaking given by the NCC pursuant to the discharge so and so, the in District Court Bhopal stands discharged.
Of course.
All orders passed in suit and in the first stand discharged.
So what happened thereafter is a very important question. This question is important for many, many reasons. If this court did not feel the necessity of explaining why the settlement arrived at endorsed, this order running from page 45 to 50 would not have been passed.
Yeah.
But if it had been passed, I say with all great respect, this order will cast necessarily, like a Delphi order, it will cast necessarily its shadow on the earlier settlement order. You cannot read it in isolation. You have to read it in conjunction with the order passed by the court, giving reasons why it went into this process. And the reasons are weighty reasons. And it has two dimensions. The reasons why settlement is important, immediate need for meeting with the agony of the people. The second is, I'm keeping a window open in case future claims come. If there are materials, the penultimate paragraph says, I think the matter of great concern that paragraph. The court was, in a visionary way of speaking, yes, I think we should not be closing this chapter with a settlement endorsement by an earlier order. So therefore, this order from 45 to 50 needs to be seen once
The one
again.
you read yesterday,
We didn't let
the
it.
order, that order yesterday.
Yeah, Your Lords have seen that.
You
I'll
pointed out the
I'll
paragraph.
come back to it with a certain clause of mine after I read the review chart. I'll come back to it again. And this review judgment, it begins at page 60. Within paragraph 38 of that order at page 59, before the review judgment, that's a very telling passage on the concern of the court.
Actually, an explanation for the court, yes, why the process was exercised in a particular manner.
No, one letter, one small sentence there in page 59. If owing to the pre-settlement procedures being limited to the main contestants in the appeal, the benefit of some contrary or supplemental information or material having a crucial bearing on the fundamental assumption basic to the settlement have been denied to the court, and that as a result, serious miscarriage of justice violating the constitutional and legal rights of the persons affected on the occasion, it will be the endeavor of this court to undo any such injustice.
This is a statement. This is a statement why the review order has been passed. Can't read it like a statute. We have to read it in the context of what is said before.
Of course.
Why this paragraph comes.
Of course. But
That
what
means why, otherwise there's no need to pass this order.
No, but this statement need not have come. The court could have said,
Now we can't.
like
take the
Union
thought
of
that-
India,
I mean,
because the court would have right, because the
I
court
find
would
it
have
very
right
difficult
to
to read a judgment in this manner.
no, because
Any
the court
judgment.
would have right to this proposition that probably we are foreclosing the possibility of certain emerging situations which may throw a better light, which may throw a better light on the whole issue.
That may be your perspective, but.
But that
To
perspective,
our mind, no, to our
is-
mind,
is-
these
is
observations are in the
intrinsic to this.
context of passing this order, whereby they gave in a way a justification why that earlier thing was done. Very difficult to read beyond that.
if the justification, I'm sorry, but I may be, because I think it's my duty to revisit this aspect again and again and again, to the extent where the
How many
court is,
times?
I know, I may be doing it, but
How many times?
pardon me for doing that. But the court was only saying that, look here, we have a reason why we went on the settlement. But then while we're also aligned to the fact that I'm not going to keep it closed forever. The court has taken upon a responsibility saying, we will undo any such injustice.
We understood what you're saying.
I know that's a way of asking me to proceed further. And
You are too experienced at review for us. You said.
I don't know if I don't read.
Because we debated this judgment yesterday, we debated it today.
Kindly
Going on
turn over
debating
to the
it.
review judge.
Now, there may be a perspective which you have, there may be a perspective we have, there is a perspective
No,
they
these
may
are not
have.
perspectives on law. These are perspectives on a very complex issue where the court did not want to close its shutters forever.
Understood, that's what you say. English language has been used, what we mean by it and what we understand, we'll take care of it.
Anyway, I'll proceed further. In the review judgments, there's a Ranganath Mishra had a concurring view, and just Venkatachala has the
Majority side.
majority view. Few paragraphs from Raghu Ranganath. Just will make a note of that, so that paragraph 6 at page 78. It's just a historical narration, but just make a mark of it. So how matter went to US courts and Judge Keenan's very effective order, it sent UCC back to India. And then paragraph 7 at page 79, which again notices that para 31 of the settlement, the May 89 order. Then kindly turn over to para 10, paragraph 9 as well. I read that. In the main judgment now being delivered, special attention has been devoted to the conduct of Union of India in sponsoring the settlement, and then asking for review the decision based upon certain developments. Is rightly indicated as a legal entity and has been given by the Constitution the right to sue and the liability of being sued. Jurisprudence, the litigating party is not entitled to withdraw from the settlement by choice. Union of India has not filed a petition for review, but in support of the stand of others, asked for review. The technical limitations of review have not been invoked in this case by the court, and all aspects have been permitted to be placed before the court for its consideration. It's interesting to note that there will be no final adjudication of mass start action anywhere. There are several instances which counsel of the parties placed before us were cases where compensation had been paid by consent or where settlement was reached directly or through a circuitous process. Such an alternative procedure has been adopted over the years on account of the fact the trial in the case of the trial could be protracted may not yield any social benefit. Assessment of compensation case has generally been by a rough and ready process. In fact, every assessment of compensation to some extent is by such process, and the concept of compensation is an attempt to approximate compensation to the loss suffered. A point on auditors also the estimate in the very nature of things cannot share the accuracy of an adjudication. Or humbly an adjudication only be an attempt at approximation. This court did take into account when accepting the settlement the fact that those substantial period of time elapsed, the victims are without relief. For quite some, the number of victims enforced before the authorities when the act was not appreciable. Perhaps an inference was drawn from the figure that subsequent addition were to be viewed differently. I do not intend to indicate that the claims filed later and particularly on account of the fact the contention and some prima facie materials show that all ill effects of exposure to MHC could manifest late. The nature of injury is suffered and the effect of exposure are not same or similar. Therefore, when the VR number, no final opinion could be reached about the sufficiency of the quantum.
Yes.
So on the sufficiency of quantum, the court says yes, some kind of an alert is kept open. So page,
Next 4 lines.
I'll read it, sir. The statute contemplates a procedure for quantification of individual entitlement to compensation. As and when compensation becomes payable to get out of the funds. The fact that the Union of India has taken over the right to sue on behalf of so and so, the shortfall in the fund, perhaps it is the liability of the Union of India to be the same. Very serious reservations on these observations. Some of the observations of the virus bench support his view, the genuine claimant does have no legitimate reason to make as long as compensation statutorily quantified is available to them because the source from which the compensation funds offend is not of significant relevance to the claimant, maybe so, but the union is relevant. Then paragraph 13. The main foundation of the challenge is twofold. The criminal cases could not be compounded, or trials and immunity against criminal action could not be granted, and the quantum of compensation set was grossly low. When the court goes and addresses the question of Rhode Island versus Fletcher and implements principle, it refers to again paragraph 31 of the Mehta judgment. Let me read it for a while. The rule in Rhode Island versus Fletcher was evolved in 1866 and provides that a person who is for his own purpose brings on his land and collection, keeps that anything likely to see. This case will keep at his spirit, and he fails to do so, he is primarily liable for the damage to the natural consequence of his escape. The liability and rule is strict, and there is no defense that the thing that is without the person will pull out, default or neglect, or even that he has no knowledge of this. This rule laid on a principle of liability. The person brings the land and collection keeps that anything like to harm, like escape centers damage to the another is liable to compensate for the damage wrought. Of course, this rule applies only to the non-natural use of land. It's not applied to things naturally in the land. The escape is an act of God. An act of a default for the thing escapes is present by the consent of so and so. Then little later, the middle of that paragraph, just after placitum D, we need not feel inhibited by this rule which was evolved in the context of a totally different kind of economy. The law has to grow in order to satisfy the needs of the fast-changing society and keep abreast with the economic development taking place in the country. A new situation arise, the laws to be evolved in order to be the challenge of new situation, cannot remain static. Evolve new principles, there are new norms which will be adequately deal with the new problems arise in highly industrial economy. We cannot allow a judicial thinking to be constricted by reference to the laws prevailed in England, or for the matter of any other foreign country. We no longer need a process of a foreign legal order, prepared to receive rights also, etc. Then, turning over to the next page, just immediately above placitum C, there's a sentence beginning. The enterprise must be held to be under an obligation to provide that a hazardous, inherently dangerous activity in the engagement must be conducted with the highest standards of safety. The harm result of so and so, enterprise must be absolutely liable to compensate for harm. Should be answered, the enterprise agent taken all reasonable care. Harm occurred through negligence, so and so. It would not be in a position to isolate the process of operations and the hazardous preparation of substance and all that. Now, kindly turn over to paragraph 17.
Subject to correction.
I'm sorry.
Paragraph 16, 17, and
I'm coming.
21 are most
I'm
relevant
coming.
paragraphs.
I'm just,
16.
yeah, I'm coming.
Why a lot of explanation has to be given in the picture, para 12. This is the background to a lot of writing. When you are saying why would the court, the background to a lot of writing.
No, would I don't know whether that background, if at all.
But it
May
is,
have, if at all.
it's not unusual
You know,
for the endeavors to pressurize courts in different manners.
I hope Union of India is not doing that.
No, I'm not saying that. I'm saying it's not unusual and therefore courts have to
But,
deal with this scenario at that time.
Yeah, they have of course voice of citizens in whichever form, unless
So,
it is
so that
limited,
it's in the background
right?
of this that certain elucidations have taken place. And there must be that as elucidations and not as some kind of a statute is all I'm saying.
No, quite right. But then probably in a situation like this, I don't know whether the citizens' voices could have come in some very organized, highly evolved, civilized way.
Sometimes they occur, sometimes they occur not so civilized, sometimes they
Yeah.
occur for
Correct.
good reasons, sometimes they occur for
Absolutely.
This keeps on happening.
Absolutely. That's true. So paragraph 16. We are not concerned in the present case as to whether the ratio in so and so applied to case that I refer to in India. We have to remain talking about the fact Indian assets are so 100 crores or so. When a decree in excess of the amount executed in the United States and one of the observation, US Court of Appeals, defense of due process will be available to be raised in the execution proceeding. Decree to obtain in Gopal Sudra money decree would have been subject to the law referred to in the judgment of the US Court of Appeals. Compensation determined based on strict liability, a foundation difference. So and so the decree would be open to attack and may not be executable. if the litigation was to go on merits of the court, it would have perhaps taken at least 10 years and appeal to the High Court, further appeal to the court, all that is said. You can therefore fairly assume the litigation would have taken around 20 years, each finality. The suit was instituted, would have taken the beginning next century, all that is there. Then after Placitum, yes, again, the court is talking about the US courts would have been the view, strict liability was foreign, the American US was in contrary to the US public policy decree would not have been executed. Apart from the Indian assets of UCL, no scope for satisfaction of the decree. What has still been court in municipal council.
You filed the curative in 2010.
November 2010.
Where is the cue from this? That's the relief would have been available to the victim at the earliest around 2000.
That's a great coincidence. Maybe ironic.
Please read further part. It's very relevant.
Yes, I was reading on page 85 at the top. So what was said was court in municipal council Ratlam, so also in capability and so. Admirable though it may be, is one slow and costly, it's a finished product of great duty, but it entails an immense sacrifice of time, money, and talent. The beautiful system is frequently a luxury, it tends to give a high quality of justice only when one reason or the other parties can surmount the substantial barriers which affects most people and to many types of claims. I try to look at it from an angle where you talk in favor of people whose access to justice is in great peril and who could not have done it except to the clutches of Union of India. So paragraph 19. In order of May 4, 1989.
18 itself is a very telling paragraph in its own way. It in a way gives a justification, para 18, why this particular path was traversed. So there is no, you're not in a utopia. So, utopia is everything should be tried quickly given, people get benefits to the maximum. That's a utopia. Now, given these factors which prevail, the assets available of the company, the nature of trial which would take place, the nature of evidence which would have to be laid, the trial period, appeal period, then the ability to execute the decree given the US courts scenario. So the London judge has proceeded to see how it would have been executed if this path would have been traversed. This is the background to which a settlement was arrived.
That's true. That's true. I mean, these are very weighty considerations. On say judicial, even litigation policy considerations, which went
We are not casting doubt on the government. We feel the government also took a pragmatic view of the objective with which any civil proceedings of this nature are launched. The idea is not to get a theoretical order 50 years hence. The idea is to provide succor to the people who are affected.
That's true.
And in that perspective, correctly a settlement was arrived at. It's not a discredit to the government of India or state. It's a credit to them that they took something to see that people receive succor. We see day in, day out, we have seen the motor accidents cases. I keep saying, claim is filed in someday. When the family needs the succor, by the time the trial takes place, 10 years pass, then we are still trying to decide. So it's a similar scenario where time period defeats the very objective of the grant of compensation at time. True. And I think already some years having passed, the government thought that those people are really in need of succor at this stage of time.
That's the reason.
These are not economic.
Even
The government would have taken out so much of money out of its pocket possibly and said, okay, you take all this, we look after you to the fullest extent.
That's right.
And then we will claim from the carbide at an appropriate stage, even if it takes 20 years.
Then different considerations will arise in a pure economic law, the commercial transaction.
You are
So I
talking
can endlessly sue.
You're talking in terms of a period when the economic scenario was one of the most difficult when these things were being done. We're talking about late 80s and early 90s, also when this is the most difficult economic scenario the country was facing.
And keeping that in mind, all these background in mind, just to be in para 124 of the Charan Lal Sahu judgment, the court also said to do a great right, permissible some to do a little wrong. I'm only saying this little wrong has remained a continuous wrong. So do a great right once again.
But
I'll come back to that passage, very
don't,
important passage. I'll just come back to it.
Diminish the importance of what the government did and rightfully did, given a particular scenario.
May I continue. Para 19, in the middle of that, there have been several instances this court has gone out of its way to evolve principles and make directions which meet the demands of justice in a given situation. This, however, is not an occasion when such an experiment could have been undertaken to formulate the meta principle of strict liability at eventual risk of ultimately losing the legal battle. That was
Exactly.
that was very weighty person.
Right.
Why the court?
Right.
Then kindly come to page.
Please read 20 also. Just couple
I'm
of-
coming to page paragraph 30.
So para 20, just read.
I'll read. Paragraph
20, just after what.
20. Very good. Those who have clamored for a judgment and merits were perhaps not alive to this aspect of the matter. They were yet so clamored, they were not to represent so and so. They are certainly misleading the public, right? Some people as settlement who have come before the court of the real victim assume that they are innocent and unaware of the rigmarole. They have been in a situation with appreciating their own interest. With the first instance, when people did nothing, they have treated the mystery. Yeah, but that's possible. And that comment is not valid today. We are on an entirely
We have to look at that day, whether it's valid or not. 50 years hence, there are a lot of steps in history which are taken, which we see should not have been taken.
Yeah.
Legally, politically, at that stage of time, can you undo everything and say, let's start in a.
I don't know whether these observations which are made at that point of time in a certain fact situation would in any way directly, indirectly color the reasoning process of the court. I say with your lordship will not be colored. But those are facts which are at the point of time.
This is the circumstances in which settlements
Then-
are saying this. We can't dump everything which is written in the past and say rewrite.
Whatever.
Now.
No,
That's
I
the
will
problem.
say,
I've been
if-
repeating it and saying this.
if for a mere re-agitation of the claims by those set of people without any change in the factual scenario, then the position is different. So we are talking about an entirely different fact situation. Turn to paragraph 30 at page 88.
Yes.
If at all in matters like this, somebody had a crystal gazing. Well, Pinto could have said, 20 years later, I'm going to foresee this. I'm not entering into a settlement, regardless of other.
Some crystal gazing was done at that stage, in a way, by the court to see where this would have gone.
So therefore, the crystal
To get
gazing by the
relief.
court, why I use
Therefore, give relief at that stage of time.
the crystal
Now,
gazing by
having
the
done
court.
that, now to say, no, now, well.
The toll of life has since gone up around 4,000, and the health of tens of thousands of so and so has come to be affected and impaired in various degrees of seriousness. The effect of the exposure, which is stored in considerably large quantities and so, both in terms of acute and chronic episodes, have been much discussed. There has been a growing body of medical literature evaluating the magnitude and intensity of the health hazards which exposed population will suffer as immediate effects and which is potentially put to risk. It is stated that MIC is the most toxic chemical in industrial use, relies upon certain studies and subject carried so and so, etc. So it was initially assumed that MIC caused merely simple and short-term injuries by scalding the surface tissues owing to the highly exothermic reaction with water. It has now been found medical research. The injury caused by MIC is not made of the surface tissue so and so, but the entire system, including nephrological, lymph, immune, circulatory system, etc. Urge exposure to MIC has mutagenic effects and the injury caused by exposure to is progressive. Hazards of exposure to this lethal poison are yet an unknown quantum.
Correct. But actually, these are all submissions. Paragraph 55 summarizes what were the contentions, and thereafter they answer to each and every contention very in detail. Paragraph 55 summarizes what were the contentions in review.
That is just when touch again.
Right, correct. That's the majority.
Contention A. The proceedings before the court were merely in the nature of appeals against the interlocutory order pertaining to the interim compensation. Consistent with the limited scope and subject matter to appeal, the main suit could not be finally disposed of. Jurisdiction of the court, the withdrawal transfer is exhausted by Article 139. The transfer implicit in the final disposal of suits having been impermissible suits were not before the court as terminable the final disposal recording a settlement. Settlement therefore without jurisdiction. Now let me focus on the other issue, contention F and J. I just skip for the time being the other issues. Contention F at page 99. Memorandum of settlement allows that the court thereon properly construed make the inference inescapable that a part of the
Attorney, a
consideration.
curative is not a review of a review. Curative can't be read as a review of a review.
No, that's what I had made.
That's why, see, for example, turn to say page para 186.
Paragraph
186.
186.
The findings are record. It has dealt with some data, etc. You have 186.
Yeah, para 186.
It talks about data, other things available, tests carried out. 187, it says the whole controversy is about adequacy of settlement funds arising on account of possibility that totality of the awards made on all the claims may exceed the settlement found even in the settlement. This is the basis. And then just read para 188.
No, in para 186 itself.
So it is discussed literature,
Very-
that possibility.
Correct.
I'm saying now in that context of discussion, please read para
188.
187. Read from para 188.
I'll do that. The whole controversy about the adequacy of the settlement could arise on account of the possibility that the totality of the awards made on all the claims may exceed the settlement fund, in which even the settlement fund will be insufficient to satisfy all the awards. This is the main concern of the victims and victim group. There now stands the fund of Rs 1,200 crores for the benefit of victims. Main attack was the adequacy rests solely on the possibility. The medical documentation and categorization where thereon the victim's medical status done by so-and-so is faulty. The charge that medical documentation is faulty and was calculated to lay down the ill effects of the exposure is an opinion not substantiated. Itself implies that the categorization of the claims on the basis of the severity of the injury is correct. And the settlement fund may not be a settlement, be unreasonable. And that was in the year 1992 when what is available now is certainly not available then.
Now read para 188.
I agree that. But you also keep it in mind that at that point of time, what is now placed in the curative petition is certainly not available.
No, it certainly it says
188.
that
At the same time.
187 also says the
I'll-
charge that medical documentation was faulty.
I'll read
was
both of them.
calculated to you just write down this. Lay down the ill effects of the exposure to MIC is in our opinion not substantiated. Now in that context, write down 188, which is
I think
problematic.
every sentence in 188 will have. I'll read it once again and say how.
Yes.
Same time, it is necessary to remind ourselves that in bestowing a second thought, the settlement is just fair and adequate. We should not proceed on the premise that the liability has been firmly established. Yet to be decided, the matter goes to trial. Indeed, UCC has seriously contested with the liability. But it's true that even if the extent the settlement goes, the idea of fairness and adequacy necessarily related to the magnitude of the problem. And the question of the reasonable must be assessed, putting many considerations into the scale. It has led us to belittle the advantage of a settlement made of its complexity. Every effort should be made to protect the victims from the prospects of a protracted, exhausting, and uncertain litigation. While we do not intend to comment the merits of the claims of the defenses, factual and legal, arising in the suit, it's fair to recognize the suit involves complex questions based on UC's liability and assessment of the quantum of compensation, mass adoption. One of the areas of controversy is the admissibility of scientific and statistical data in the quantification of damages with a resort to the evidence of injuries in individual cases. Having said all that,
It says it proceeds on a basis that UCC
correct.
liability is yet firmly to be established.
The
Now, in
story,
purity, how can we burden them with this in respect to a settlement? And say
If-
no
if-
trial, nothing.
if-
We just increase the quantum because you are at fault.
if,
On
if
one hand, there are observations.
let us reach further. Let's reach further. If the review judgment lays a certain foundation for even a minimal relook at the whole issue on any supplementary material.
What
that's
we
noted
have
in
pointed out to
Hey,
you are findings of the court, not
I'll
arguments.
let me
Large
complete.
part of else which was read was arguments.
Let me complete reading some of the paragraphs, and probably that will emerge from the reading of the judgment. But therefore, if the review judgment had some reason to say, regardless of the complexity of the matter and the great purpose behind the settlement and avoid protracted litigation, etc., regardless of that, if the review judgment still kept open a room for even a minimal look, and I'm only saying,
Actually, it proceeds on a premise we have not yet established the liability of the respondent. It is
I'm
one
alive
of
to that.
trials.
I'm alive to that.
Then how do we
Let me-
pass
therefore-
on a presumption
therefore
of
we have-
liability on them?
No, the
Beyond a
settlement is
settlement.
based. The settlement is based on a certain liability principle, which UCC said yes, because the US court does not have jurisdiction for a non-convenience. The Indian courts will have jurisdiction. Therefore, the question of jurisdiction is finally settled. The question is what will be the quantum of compensation is an entirely different question. That question is entirely different. So therefore, on the question of jurisdiction, there is no going back.
There is no trial, there is no determination, there is nothing.
Therefore, they wanted to avoid.
Two parties.
Union of India wanted to avoid a trial.
No,
UCC
exactly,
wanted to avoid
exactly.
a trial.
Two parties decide to avoid a trial, settle on a figure. They may have their own business decisions to settle. You had your own reasons that the time periods and the manner of fixation of liability would take it very long. You agreed to settle. Now, without any of the substratum of a suit trial, when no finding has taken place, you want to
That
fasten
would-
additional liability. How do
in
you
a-
do it? Under what principle?
In la-
Earthly principle of law do we do
in
it?
large number of such mass transactions, settlements do take place.
Yes.
That's it.
Agree.
Because you have a certain give and take. But then who gains out of it?
Don't know.
For commercial reasons, for business proposals, UCC says I'm going for a settlement. Then tomorrow it is found, and I'm trying to find. Tomorrow in a case it is found that you settle on a very poor scale. You settle for a very poor scale. That's why the doctrine of tracing restitution, you avoided a certain expenditure, avoiding, escaping expenditure. That could always be taken. That's why you avoided it. You know that in future you will have a certain liability. You want to settle it quickly. Union of India at that point of time said, well, yes, I want to even
They
give a
waive-
succor to the victims.
They weigh the possibility that if an adverse view would come, what are the consequences which may flow? You weighed that if you're not able to get the right kind of judgment, and even if you get the right kind of judgment, how to execute it, how will it operate? These are calls taken, and this judgment deals with it and says, look, justifies in view of all this hullabaloo at that time which was there, because there were a section of society feeling, no, this is not fair to us. Therefore, such a long judgment explaining what is sought to be raised, why people sometimes are not understanding what is best for them. The government did what is best for them, the court did best for them. Now you say, no, the government also did not know what it was doing. Court also did not know what it was doing. Nobody knew what it was doing. Start de novo.
Let's kindly go to paragraph 198.
Yes.
I would have said yes. The observation is absolutely valid because in a different context, they would have been unquestionable. But in a context like this, I think there's a need to go beyond the customary principles of tort law and negligence, economic laws, the gain laws, etc., will all be kept aside. So, paragraph 198, page 157. After a careful thought, it appears to us, while it may not be wise or proper to deprive the victims of the benefit of the settlement, it is our necessary to ensure that in the perhaps unlikely, even to the settlement fund being found inadequate, I mean, the compensation determined in respect of all the present claimants. The court was still talking about the present claimants.
Yes.
Those persons who may have their claim determined after the fund is exhausted are not left to fend for themselves.
Yes.
Such a contingency may not arise having regard to the settlement of funds. These are all a certain set of assumptions. If it should arise, the reasonable way to protect the interests of the victims is to hold that the Union of India, the welfare state circumstances also should not be found wanting to make good the deficiency of any. We hold and declare accordingly. Is this principle a valid principle? So in the curative petition, we say this principle needs to be revisited. So the court left this open. There is the possibility for the present claim. And then in 1992, the number of claims were registered were not even complete. By 1996-97.
The judgment goes further. The judgment takes a note that medical evaluation is still incomplete. And if some claims arise out of that completed medical evaluation, what is to be done? That is also mentioned in paragraph 206 and 207. You may go to that later on. But there is the answer to that. That if more claims will arise, who those claims are to be dealt with?
Who should bear the liability?
Right.
Who
And
should bear the liability?
there is a complete answer to that. First
The
is
answer is Union of India will bear the liability.
Yes.
206 and 207.
The question of why this is what you agreed to.
So the question therefore is, if there is a need to look at it, how did the court put it? Court put it well, yes, parents patria, there is your Union of India will step in and bridge the gap. And because
So Union India came forward as parents patria to file this suit.
that is for a different purpose.
Wait. You come to your plaint and see on page 216II that the total claims made at that time were already registered at number 5,31,770. There were 2,660 deaths. And you have given the figures also that this would be the approximate
That is
same.
true.
Correct.
That's true.
And then you see the relief claim. And then ultimately you entered into a settlement too. In February 1989.
February 1989, the process of understanding the magnitude of the tragedy and then
No,
enumerating
the claims of 5 lakhs were already registered at that time when this was filed.
they were only part of the persons who were affected. We had 10 lakhs people who
Just
came
one
to be the. So therefore, about 5.
Explain how many did you find worth giving?
5,74,000.
50% of the claims you also rejected. You meaning the concerned authority rejected it. Let's not raise numbers theoretically.
Not theoretically, it's after a factual enumeration.
After
By
factual
the-
enumeration,
by-
you are
by-
talking about 10 lakhs, while actually you found, or the concerned authorities found 5 lakh claims worth.
Correct. That determination is as to a process of
Yes.
law,
And
through a
so
statutory process.
What would happen if more medical issues arise? As my brother points out, para 206 talks about a scheme for it.
There is a scheme under the Act. Under the Act, if the court takes cognizance of the scheme, and under the scheme, if the welfare commissioner has dealt with all the applications with a final date for registration, and in 2004 you find these are the number. So therefore, either you completely give a go by to the statutory scheme or the Act, the settlement is final because Union of India could not have done better at that point of time. Close it. But if the statutory scheme has been endorsed by this court, if the Act has been set aside, it would have a different scene altogether. The Act has been set unconstitutional. The scheme was received with imprimatur by the court, and under the scheme, proceedings have taken place. So does the proceeding do not have a
Paragraph 206, 207, and 208 take care of two categories of claimants. One, where those who are already under treatment, and secondly, those who were born subsequently, who were affected by this. Both the categories are taken care of by paragraph 206, 207, 208. Both the classes of cases are dealt with.
They are in great respect in substitution of the liability of UCC
Yes.
and in substitution of the liability of UCC for whatever reasons the court might have thought at that point of time.
Whatever reason they thought and you thought also.
No, the court, with the great respect, the court thought that.
Court on the arguments that tried to structure it further. This may arise, so let's do this. This may arise. Otherwise, once the settlement is done, it's done. Chapter is
So
closed.
there are therefore
In your wisdom or lack of it, you settled it. And it is not lack of wisdom. You knew very well that the problems which have been sketched out in these judgments. Why you did it? The court gave its imprimatur because there was a thought process involved behind it. The thought process was valid. Money would not have seen the light of the day. You knew it.
Now,
For 2 decades, the money would not have seen the light of the day.
I did not.
Today, you want to fasten on knowing fully well that for any court to be favorably considered, it will never see the light of the day. The money.
No, I did not present any canvas, any argument or a proposition that the settlement should not have been arrived at that point of time at all. The Union of India probably did the best at that point.
Right thing.
And so many things happened. Canvassing against it or in favor of settlement.
So just see
So-
paragraph 205 onwards as a complete scheme, which is part of the judgment. We
This
don't know- we
then
don't know
comes
the
to the question. No, but I thought you logic
Was this scheme implemented ever? Was made or implemented?
Just read that.
I'll read that. I'll read that.
Here.
My instructions are it has not been implemented. Of course, it will structure. I instructions.
No, it's a matter which Union of India has to bear a responsibility, if at all. The done or not is a different question. But as far as
Did you do
UCC
it?
is concerned,
Did you do it?
no, whether do it, that's a different issue. But UCC
Maybe a
cannot be
different
held
issue.
to
Did
say-
you do it?
Great
My
respect.
question is, did you do it? Yes or no?
I'll address that question, but UCC
It's not a
cannot
very
be.
simple answer either, yes or no.
Mr. Parekh is saying you have not done it. That's what he's saying.
I'll just tell you. No, but my submission response to it, UCC cannot be heard to say, oh, here you were a possibility where all these additional claims can be settled. The court has looked at it, therefore I'm a free bird. They certainly cannot say that. And
Should not be.
to 3, the court proceeds to dispose of all those contentions and in answer to
Yes.
it reiterates at page 163 bottom
Beyond
what is
that,
stated in para 188.
the policy should be taken for not less than 1 lakh people. Then how the claims will be honored, it is all mentioned in paragraph 208, 209. The scheme which is devised so that any claim arising in future is paid through insurance. It's paragraph 207, 207.
209, 2010, yes.
Also, paragraph
Detailed
21. Paragraph 221.
As a complete scheme which deals with not less than 1 lakh people whose claim may arise in future.
Page,
So whether your curative petition says,
para 209,
correct, whether curative petition says anything about implementation of these directions.
it doesn't.
Doesn't say that.
Para 209, the premier for the insurance shall be paid to the Union of India out of the settlement fund. Not an independent fund to be created.
But out of the settlement fund, again, I'm
So therefore, how much do I
Time
put?
for the-
How much do I put my hands into the settlement fund? And then,
how much
therefore,
the settlement
if I have
fund is still
No.
with what Mr. Salve points out, still 50 crores of the settlement fund.
that 50 crores, and that will answer that question. The 50, there were 435 claimants. whose case was decided for a number of reasons. The cases are still pending. 50 crores will be discharged to those who come forward take this money.
So where
There's
is
nothing,
it?
there is nothing which is remains undisbursed.
It is remaining as on
No,
today.
no, 435 applicants.
39
So there
days,
is a-
it is 30
there are
days,
some
it's
appeals
still
pending.
undisbursed.
No, no, 50
What are we
crores
talking
is
about?
not what we are probably talking about.
No,
We're
but
talking
so we take it that
Yeah.
this entire scheme, though at that time money was available
Yeah.
out of the settlement funds, this scheme was not implemented.
Right, because this, the adequacy of the amount itself got exhausted. You got it exhausted by
In
paying.
in 1991, the
No, no,
amount got exhausted.
not
This
in
is 1991 direction
Not
to
in
take a
19
policy for not less than 1 lakh possible
You
claimants.
got to look at, I understand that, but
Right.
it was not done. But the question is, I'm trying to look at it from a very broader perspective.
No, but is
Well, in
it?
1990,
No, we are asking a
Your
question.
Lordship, I just come back to
No,
the correct.
ask you very,
I'll come back.
now, we understand your concern for the claimants. People are raising voice. You are absolutely right. But here is a case in 1991, court directs you to do something, which today we are on 2023. Till filing of curative petition, do anything for 19 years. And now today we find a scenario that this would have helped at least lakh of people, not if not more. And that part is not implemented by Union of India.
I'll come back with a precise,
for that.
with a precise set of.
It would have helped more than 1 lakh people.
I will come back.
Because the paragraph 206 says for not less than 1 lakh claimants, policy should be taken. That's what the direction is.
I'll come back to that.
You've not done something about it, then we'll have to say how you work with the government.
I'll see how. Is it volume on? Is it the-
Just wanted to say one thing. The attorney not asked about the parents' patria. When we may not challenge the act, because of the other, we were part of the challenging group. Challenge the Bhopal Act 84, saying you can't take away my basic right under a rule of law to bring an action. Your lordships upheld it, saying the government of India successfully argued, parents' patria, we are entitled to take over and represent the people. Now, if you say parents' patria is wrongly applied, then that act is a question mark, then your suit goes for locals.
I'm not canvassing proposition at all. The Parents' Patria Act, I say the power coupled with the duty. If there is injustice, I must undo the injustice. I'm not saying I'm relieving myself of the Parents' Patria responsibility. In fact, by filing the curative petition, I'm discharging that responsibility. You also may pick up volume 1 of a compilation of judgments which have been proposed. Let me say to me take the lordship to the Buddha.
No, this will be distribute. So at that time, you could have easily done that. You don't refer to the funds now available and say with reference to 435 cases, those may be distributed there. You see, what's being highlighted is, we appreciate your concern. We are not, but one is the issue with regard to the limited jurisdiction we exercising, which you are saying we should extend. But this question has been addressed squarely and completely in the review application. Because by that time, substantially 370,000 odd claims had already been verified. And
Right.
Claims had been granted.
Right.
So they were aware that further claims were arising. It's not that they were not aware. They were also aware of the facts and figures. They were also aware of the facts and figures at that time. So And the formula which you have devised, the three-step formula, which is at page 3 of your appendix A, is a little debatable. Let me put it very clearly, it's very, very debatable. The figures and data can be changed, and, understood in different ways. And the difficulty is you should have done that. The difficulty is you should have done that. There was some direction given, and that cannot be ignored. That could have been easily done.
On a balance of.
And they are finding that at that time, as per exchange rate, 1,200 crores were available. That's also a finding. So this amount could have been utilized part of it.
All that is, I have two scales on my hand, put all in one scale. The other scale is this whole journey of doing complete justice to the claimants is final or not is a question which I'm trying to ask repeatedly. For that, what are the things I must put in the other scale? The only thing that I can put in the other scale is that repeatedly again, the figures which are now merged out. And we just take a note of in paragraph 37 of the first order. Sir. So which scale will go down?
Possibly the government is in default.
Lord, kindly turn to, you also have that comparison.
Yes.
Well, I will only read those relevant paragraphs which have some light on this whole issue. Paragraph 16 at page, running page 16, the top. Yes. And before that, and paragraph 14, the court looks at post ancillary is all begun to happen, filing writ petitions and assailing. So paragraph 14, on the analysis of the ratio laid down in the aforementioned cases, we reaffirm our considered view. When a final judgment order passes, court cannot be assailed in application of Article 32. When agreed person whether you are the party to the case or not. In 16, however, all the learned counsel for the parties, also the learned attorney general, appeared as amicus curiae in the notice of the court. Adopted an unusual unanimous approach to plead that even after exhausting the relevant review in Article 137, an agreed person, I'm reading my comparison. Page 16. An agreed person may
Bhura's judgment is part of Bhura's judgment with the attorney. Paragraph 16.
An agreed person may be provided with an opportunity and the inherent power of the court to seek relief in cases of gross abuse of the process of the court or gross miscarriage of justice, because again, the order of this court, the affected party cannot have any recourse to any other forum. Then paragraph 23, the intervening paragraphs are all submissions. Paragraph 23 at page 19.
Yes.
These, just about that, summing up that the previous paragraph, the last line, so and so, etc. The exercise of inherent power for correcting the manifest illegality and palpable injustice dismissal review petition has been narrower than the power of review. These contentions pose a question whether an order passed by this court can be corrected in the inherent power after dismissal of the review petition on the ground it was passed either without jurisdiction, violation of principles of natural justice, or due to unfair procedure giving scope for bias result of the process of the court, or miscarriage of justice to an aggrieved person. And then 24, there is no gainsaying. Supreme Court is the court of law assessor, the final court in question both of fact and law, including constitutional law. Declared is the law of the land, is teaching for itself for all court tribal authorities. With declarations of law and application of the facts of the case, the decision and dispute on the parties the list. Necessary to bear in mind the principle with regard to the highest court department of binding proceeding, the difference on the grounds on which a final judgment of the parties can be considered. Reconsidered, here we are mainly considering the data. However, when reconsideration of judgment of the court is sought, the finality attached both to the law declared as the decision made in the case is normally brought under challenge. It is therefore relevant to note so much was the value attached from the highest court in London, so House of Law based on which upon a question of law was conclusive was by the House subsequent case. An earlier decision could be set right only by an act of Parliament. Then paragraph number 40. The court again looks at a large number of cases on bias, qualification, natural justice, and all those dimensions where opening of a judgment may present a very important, aspect of consideration by the court. There's I want to place with lots of consideration. There's a book called Black on Judgments, American, fairly dated, but there again talk about those very unusual cases where a judgment or decree can be amended if parties have gone on a mistake of fact. Like Section 22 of the Specific Relief Act, you can rectify an instrument. And some courts have taken the view an instrument would also a decree or a compromise. So these are the canopy of views on how a judgment will be looked at if there is a reason to depart from an earlier view taken. Now, paragraph 42. The concern of this court for rendering justice in our cause is not less important than the principle of finality of a judgment. We are faced with competing principles ensuring certainty and finality of judgment to the court of last resort, and dispensing justice to reconsideration of a judgment on the grounds is vitiated being in violation of principles of natural justice, or giving scope for apprehension of bias due to a judge who participates in the decision-making process not disposing things, or an account of abuse of the process of the court. Such a judgment, far from ensuring finality, will always remain under the cloud of uncertainty. Almighty alone dispenses the advantages of the concept not so and so. We are of the view that though judges are the highest court, they are subject to limitation of infallibility. Situations may arise in the rarest of the rare cases, which would require reconsideration of a final judgment to set right miscarriage of justice complaint of. In such case, it would be not only be proper, but also obligatory, both legally and morally, to rectify the error. After giving our anxious consideration to that question, we are persuaded to hold the duty to justice in those rarest of rare cases shall have to prevail over the policy of certainty of judgment, as though it's essentially in the public interest.
Yeah, really, it's a reopening of a settlement which you are wanting. Reopening of a judgment. Therefore, the principle which applies to the case of order. You yourself say we did not know.
Yeah.
It's like, did not know.
The
Judgment gives its imprimatur. You discuss many more. You give the imprimatur to a settlement that two parties willingly have arrived at.
would exceed 3,900 crores.
Without duress, fraud, or pressure.
देने की बात नहीं की.
But in purity, you say no, this imprimatur which was given by the court to the settlement itself needs to be opened. Same breath, you say no, don't open the settlement. Enhance the settlement. Vary the terms of the settlement. About the variation of the terms of the settlement.
That's I,
Keep saying under what law is what I'm saying.
if opening up is possible, and this is contemplated here, to do undo miscarriage of justice. So court cannot possibly lay down like a parliamentary legislation in what circumstances this can be done. So even a very ordinary case, mistake or a fact, a settlement or a compromise is undone by act. And the court says, yes, there's a miscarriage of justice, my inherent powers will be certainly
Where is
invoked.
what is the mistake
So
of
if,
law? Yeah.
therefore, if that, and fraud has been defined so widely, mistake, a mutual mistake, sometimes based on an inducement of an acceptance of fact is a fraud.
But that's not your case,
So
that there is any mistake or
Therefore,
fraud.
I'm sorry.
That's not your case.
No. My case is the errors which have gone into or the assumptions of facts relating to who is entitled, how many persons are entitled, and what quantum of compensation. That assumption, which has been noticed by the court in the penultimate paragraph in the May 418 and order, that assumption is proved to be wrong.
If you have entered into a settlement, your view is
That assumption is proved to be wrong.
assumption entered into by one party.
Yeah.
On a settlement entered into by one party on certain assumptions. If later on, much time later, the party finds those assumptions were not correct, there's a ground to open a settlement.
Increase.
45%.
Yes. No, that's why I started saying.
This is why, just think of it, Tani. This is what the proposition will amount to.
If all my endeavor is
And also,
make good.
under the judgments of the court, what I was required to do, I have not done. But don't tell me that I have not done something which I was required to do. I am a default.
That's what you're not putting to me, whether I'm in default or not. I'll try to come back to it.
If you have done it, you are not a default. If you have not done it, certainly you are majorly a default.
No.
Causing
probably-
for some embarrassing, in this unit, some embarrassing comments on what you have done or not done in the Union of India.
After giving our anxious consideration to the question we have persevered to hold, that the duty to do justice, the rarest of rare cases, allowed to prevail over the policy of certainty of judgment, although it is essentially the public interest that a final judgment or the final court in the country should not be open to judge. Yet there is circumstances mentioned above wherein declining to reconsider the judgment would be oppressive to judicial conscience and would cause perpetuation of irremediable injustice. That's how it's like a very important way of perceiving how irremediable injustice in a given set of facts is certainly always in the domain of the court. And my only endeavor is to say that look at the totality of the facts, put them all together and see where do we ultimately arrive. There could be a small dark spot here, a gray spot here, and things like that. But the ultimate analysis, if the court were to be told that for this very important reason, in the number of persons, adequacy of compensation, that important reason I say is one of those rarest circumstances with the court visualized to reopen in paragraph 37.
If I'm again saying it's the cost of reputation, subject to your verification of the court something. If you have not done what that judgment and review ought to be done, why should we not say that you must bear the consequences of it because you are responsible for that situation?
I'd endeavor to see if I can put in a perspective on it. I'll try to see how
I really can't, none of us can find a perspective to it other than either you've done it or you've not done it.
Yeah, and I said,
For that you'll get it. If you've done it, well and good, no difficulty. Because under those policies also then compensation may have been received. Which you were supposed to take, it is possible people may have claimed and received compensation under those policies with passage.
Let's then go into paragraph
On the
48.
Insurance, just a factual thing, the attorney will of course check. The conditions on which the money was transferred to the Reserve Bank, and that's how we assumed this is all being done, said, no part of the fund shall be utilized or withdrawn or utilized to meet any administrative expense diverted for any purpose other than payment to or applied to the satisfaction of the victims. The fund may also use insurance premium as scheme of insurance indicated. But where the question of premium is, there is insurance policy.
It's Sarve in a lighter vein. Yeah, appreciate your intervention. We can't forget that all this happened because something happened in your factory. You can't forget that.
Not my factory, the Indian factory.
Because at one point of time, it was your factory. Yes.
That's
Yes, sir.
Paragraph 48 at page 29.
Yes. Yes.
I was just looking at the numbers, the very number of cases which was quoted, looked into from a very ordinary, what one would call a
what
service
I was
law
saying.
dispute.
I may just share an anecdote. So Nariman was leading the battle on our side. India's finest civil law lawyers. But he applied for further and better particular injuries. That's why the government said, so reality, giving names and details of injuries became impossible. That's why the suit was floundering. That's why in para 188, the Lordship said without proof of individual injury, where would the suit have gone is the question. That's why the district judge got frustrated and said, all right, in the meanwhile, pay this 400 crores. High Court said 250 crores. That's how the matter was. And your Lordship, as my Lord said, I remember that time the Chief Justice, unfortunately, we lost him halfway through the review of Justice Mukherjee. At that time, the first time when it came up, Chief Justice parted. He said, but surely, Union Carbide must take responsibility. Mr. Nariman said, yes, we are willing to pay for this much fee. That's how the whole thing started.
But of course, so Nariman also said the greatest mistake of my life.
He said that.
I have placed on record, just by way of digression, I placed on record
It's a social
two
thought
reports.
process,
Two
yes.
reports.
Whether somebody should defend the party or not. It's a many social
I now
ramifications.
practice in another jurisdiction where we are given by the Bar Standards Board. It's a very interesting expression. It's called the cab rank rule. If it is in your area of work, if you are offered a reasonable fee, and if your diary shows you are available, you cannot say no. And there's no question of I don't like this case. So my clerk in London has to keep my diary even if I'm here. So that if an offer comes for brief, he says no, he justifies.
So the change is your diary may have gaps. That was difficult to find here.
I will make an application to Mellon for disclosure. Yeah, I was just trying to say that I placed on record, I'll not trouble Lordship with that, two reports by Mass Stars working group in US, one showing the difficulties in the reason why settlements are entered into, and sometimes why settlements need a second look. There is some concern there.
Just,
There's a whole range of cases there.
Mr.
And
Tony,
the second also, I'm sorry,
can you just also read paragraph 52?
paragraph
52. At page 30.
Fifty-two. I'll read a couple of them.
I think your
And just
answer would
finish.
be, don't have a
I'll read paras 48 onward, so that Lord forbid me to do that. In the cases discussed above, this court reconsidered its earlier judgment, inter alia, and the articles 129 and 142, which confer very wide powers in the court to complete judgment parties. Indicated about the scope of the file before Article 129 and the Code of Record also advert to the extent of power under 142. The upshot of the discussion views that the court, to prevent abuse of process and to cure a gross miscarriage of justice, may reconsider judgments in excess of the inherent powers. The next step is specify the requirements to entertain such a curative petition and the inherent powers of the court. The floodgates are not open for filing a second review petition as a matter of course in the guise of a curative petition and the inherent powers. It's common ground, except when very strong reasons exist. The court should not entertain an application seeking reconsideration of an order of this court, which has become final dismissal of review petition. Neither advisable nor possible to enumerate all grounds on which such a petition may be entertained, and that's a wise statement of judicial policy. Nevertheless, we think that a petitioner entitled to relief ex debitio justitiae establishes violation of the principles of natural justice in that he was not a party to the lease, but a judgment adversely affected the interest, or that he was a party to the lease was not served notice so and so, or where in the proceedings with earned judgment discovered connection so and so, apprehension of bias and judgment adversely affect the petitioner. The petitioner shall, the curative petition shall aver specifically that the grounds mentioned in taken the review petition and the regulation will contain clarification, certification of the senior advocate to the fulfill the judgment.
So,
Here are the view that no matter
what is the effect? Of course, you
of the
said
final judgment.
you'll come back to it later. What is the effect?
Let me complete reading a few more paragraphs and write.
Our job would have been
How I may fit in. How I may fit in.
our job would have been very simple on the first day and the first 5 minutes. But we thought that looking to the issues involved, we wanted to hear you at greater length. But can we just brush this as a brush aside? This very factum objected to, and though we have committed almost a day and a half hearing that very jurisdiction of curative is conferred under this judgment. In what circumstances the curative would lie is specified. If that condition is not specified, what happens?
Implicit in the
That is right. This case, 52 has not been observed. 52 is not been. Buddy. 140.
petition before it was. Because honestly, we are dealing with a few hundred curative petitions. Curative petitions also, we also deal with it summarily.
So next step.
There are specialized councils in the curative petitions who sign curative petitions.
I can only
Just
read
saying how, but see, it's like none of us are laymen. All of us are governed by law.
absolutely.
All of us have to follow a process of law. Therefore, the process of invoking a jurisdiction requires A, B, C to be done.
52 is not being done.
Has it been done?
You see
Let me
that.
take-
What my brother is pointing out,
Let me-
we didn't want it the threshold because we flagged it the threshold, but we said that, okay, you are feeling strongly about some issues as attorney or we are
I'm grateful
you are
for the-
entitled to this.
I'm grateful for the indulgence.
Entitled to this audience from the court because not only of the office you hold of for a number of years, but ultimately we have, I mean, normally a petition on this ground alone without saying anything more could have been dismissed. It has been kept in open court because of the issue involved. Therefore, we have,
Lots of time.
please tell us after lunch the two factors. One, did you invoke the insurance? Or two, where is the certificate as required in Pura's
I'll take the curative petition. It is at page 193,
161.
161,
Petition. 160.
page 161
How does it say
of the curative petition certified by the then Attorney General.
does it say whether a review has been filed as required?
Now, that aspect I'll address you now. That aspect, whether there is a judgment of your lordships in National Commission of Women in so and so in 2014 for SEC, where the National Commission for Women, who did not file a petition, was permitted to file a curative petition, and because of the importance of the issue involved. So it is a precedent and been entertained.
There is otherwise a threshold bar for you. If still,
That's why
I think we still heard you because I don't think whether any other curative has been argued for a day and a half, but at some stage, all good things have to come to an end. Yes, after lunch.
I
We'll
will
take it up at about 2:15, but I have one special bench at
Very
3 o'clock for 10 minutes.
very
Yes, certain.
Once.
This is the database. X. Question difference. Yes, please.
On the first question about this insurance, I have some observations to make on the paragraphs 205, reference to para 133 of the judgment. I'll come back on the question as to whether there was, and then in view of the fact there were two things which happened, please turn to 205 at page 159 of volume 1 of the respondent compilation.
Yes.
Then comes the question which we posed at the end of paragraph 135. This concern.
Just 1 second.
I'm sorry.
Sorry, I didn't get it. Page?
This respondent number 1 compilation, the review judgment.
Okay.
I may as well go back to page 132 at the bottom of para 135, which is what's referred to in para 205. 132 bottom, just below classical case. What about those who are presently only asymptomatic and have no material to support a present claim? We will provide them medical surveillance costs, and if someday in the future they develop any other dreaded symptom, we will provide them with compensation. Even if the award is an once and downward determination, these aspects must be taken into account. Then 205 at page 159. Then comes the question which we posed at the end of para 135. This concerns the exposed members of the population of Bhopal who are put to risk and who, though presently asymptomatic and filed no claim for compensation, might become symptomatic in future. How should case of yet unborn children or mothers exposed to MIC toxicity, but the children are found to have or developed congenital defects be taken care of? So kindly turn over to the directions part of it.
Yes.
And which is at page 164.
Yes.
Subpara D. In respect of the population of the affected wards, excluding those who have filed claims, Government of India shall take out an appropriate medical group insurance, so on, etc., for compensation to those who are presently asymptomatic and filed no claims for compensation might become symptomatic in future, and to those later born children who might manifest congenital or prenatal MI affliction, that no upper individual monetary limit for the insurance, the period of insurance so number is 1 lakh. Therefore, I'm told that in view of two developments, one that about several hospitals that have been set up, including the hospital, to take care of the medical needs of persons who might not have filed claims at all, and which seem to be still keep coming. So the medical facilities and free insurance, free medical facilities there seem to be taken care of this aspect of the matter. But I'll come back on the question as to whether government actually applied its mind on this and how they took a decision. I need a little more time. I would like, because that's not very clear today, but what I am told is that in view of this, the medical part of it being taken care of, whether the compensation will also be input, that I don't want to make any statement which will not be accurate.
You are saying medical needs are taken care of by free treatment in hospital, so we don't need to take out insurance.
No, I don't. That's information given to me. I would like to verify this. Please.
But that
I won't be in a position to make
this
any
Bhopal Medical Hospital has now been closed. It has been given to somebody else.
No, there are 6 other
That's fine.
hospitals which are where medical assistance is being.
For this purpose, when the hospital was started,
The Bhopal
that is now
Memorial
been-
Hospital.
Memorial Hospital, that now been closed.
But the other medical centers where people go for their medical treatment, they are still functioning.
Cover the added cases.
I'll come to this. Claims and were already covered under various categories of disability, ailments, etc. So these are that's why excluding.
There appears 5 to 6 categories of that as per the scheme. And out of that, those persons who fall within that category, they are being provided. the
There could be
medical
other categories also. But that's how, for instance, cancer. There are other 2 categories for those 2 categories, where the ex gratia payment were made in 2010 and keep making payment up to 2022. The government has continues to make payments for those people. The applications are not closed as far as those are concerned. I put it so in my note.
Yes.
Therefore, that's an entirely different set of people, other than those who filed claims, 1 lakh earlier, which then now has become 5.74 lakhs. And so that perhaps should not be reckoned for the purpose of considering D, paragraph D. So, but I'll come back on the question whether there were conscious decision taken or not as far as the insurance. So what Government of India did on that, I'll come back on that question. I need a little time. But I want to make this preliminary explanation saying this, what was intended was only to cover those who are not part of the present claimants set of group. And if there are others who may deserve an assistance of compensation, how do we take care of it? That's how the court probably looked at it. Let me come back to the trust for this, or the hospitals, the 6 hospitals I'm told are functional and they're taking treatment from those hospitals. So that's how the research by ICMR, it continues to happen. Post 2016, studies keep happening and place on record how the categories of other ailments come to the notice of the ICMR research process. So in 2012, this court said you must continue to have this medical facilities, have a research facility, and ICMR will do that. All that is a detailed set of instructions are being followed. I was drawing your Lordship's attention to the National Commission for Women's Judgment, which is in volume 1 of by compilation of judgment. What I would like to probably say is that there is one instance where the strict requirement of party filing a review petition or parties to the proceedings and then successful in the review, thereafter filed the curative petition. There is one case where your lordships, by reason of the importance of the case involved, permitted the National Commission for Women, were not a party to the earlier proceedings, and they were permitted to file a curative petition. The curative petition was granted. So there could be any number of instances where, in grounds of public interest, public importance, public good, where
They were not party to the original proceeding. No?
NCW was not a party.
Therefore, they referred to
Was never a party. And here, of course, in the review judgment, lots of notice the paragraph where the Supreme Court says that we supported the review, even though we did not.
para 51, that is why it says of Hurra's case that entitled to access to justice is a violation of principles of natural justice. In that, he was not a party to the rest, but the judgment adversely affected interests, possibly coming under this first category, not being a party to the rest.
No. NCW interests were not affected, except as a public body,
Not to,
who has an interest.
not to represent the interest of the, he was not party, but to represent the interest of a category of people.
Correct. Therefore, Union of India stands on the same footing.
You are party.
I was a party, but I have a larger interest than NCW. I have a greater interest.
You are party
because-
to the proceeding.
That's true. But what I'm
That's
trying to
it.
point out
You are
is
party to the proceeding, party to the settlement, party to everything.
no, that he was not a party to the Lisbon judgment adversely affected the interest. Therefore, your lordships put it on a wider footing. It is not at a personal interest. It's an interest of an institution.
That's why
It can be the
in any
interest.
case you had stepped into their shoes today.
Correct. The
There's no
interest
doubt
of the
about that.
institution.
Yes.
So if the interest of an institution is paramount, and certainly your lordship permitted to do so.
Yes.
So the strict requirements of only parties to a list, and in the absence of filing a review petition, you will be precluded from proceeding with a curative. I think that
All I'm
is,
putting to you is that was a party, not party to the list, sought to represent the interests of a group of people. And in that position, the curative was entertained. That's what I'm saying.
let me read that husband, but the
What will that do? Does it say discuss all this?
the context is that an institution which tries to represent a certain interpretation of provisions of the Indian Penal Code. The question is not who comes, but the question is what is the public importance. And there is an interpretation question which affects a large number of people. So the question is therefore if there could be any number of such circumstances where public good or a public interest or a constitutional interpretation or an error of judgment which leads to miscarriage of justice. So all those will fall in the category of permitting.
Your deep research also you have found out this order is the only order.
But
yeah.
I'm only looking at para 51 to say that the very strict reading of 51 will not come in the way of Union of India not having filed a review petition can still maintain a curative petition. It is one example, which is a recent example. Examples could be multiplied, perhaps.
Different facts, how it is done, why under 142 it is exercised. Issue was raised about locus standi. You turn to para 10.
Locus standi in the sense of participation, the presence of.
They have entertained firstly, it's an order. There's no judgment on this issue. You should have overlooked. But it will entertain to that extent, you are right. But it said so in view of these facts.
That's true, but the facts are. The view that so far as the objection relating to the locus standi concerns the same is not tenable. And according to the fact that we are not dealing in this matter with a statutory right, but a constitutional provision, the Article 142 of the Constitution. And in fact, and Article so and so pass orders to justice between the parties. The issue involved is not one against Monica alone, but the interpretation or the expression cruelty within 498A. And in paragraph 1, and in paragraph 214 of the review judgment, paragraph 214 at page 162 of the review judgment, disposing of those 162 bottom and 162 top. Let me read it. We might now sum up the conclusions reached, finding the recurrent directions related contention. 1. The contention that the apex court had no jurisdiction to withdraw to itself the original suit pending in the district court at Bhopal and dispose of the same in terms of the settlement. And the further contention that similarly the court had no jurisdiction to withdraw the criminal proceeding that rejected. What's the reason? The reason is given at page 163. It is held that in Article 142 of the Constitution, the court had the necessary jurisdiction and power to do so. The suit was virtually withdrawn before this court. And all proceedings were under Article 142. The settlement, endorsement, the further review disposal, everything was under Article 142. So that's why even in this case, when the court says, we are looking at 142 to permit National Commission for Women to be a party to a curative proceeding, virtually it's almost the same logic. And having said on 42, paragraph 11, the court says National Commission is enjoined to certain statutory duties, and therefore the court considers it in the fitness of things to permit NCW to file a curative petition. I would probably urge, there's the instances can multiply in future now. How it happens, one does not have to speculate now. But in the facts and circumstances case of this very hugely adjudicated issues, and with two important judgments as milestone to throw some light to this matter. If the curative petition proceeds to present a very highly arguable question of an error vitiating the settlement for a good number of reasons, I say with great respect, the curative petition has been rightly presented in the larger interest of justice to the Bhopal
In this
just
National
victims.
Commission's case, we will kindly say that this was a case filed by the curative petition of the National Commission for Women in the creation members were and criminal appeal members were disposed of at the court of judge. You know, they have filed the petition, then they are up to the curative.
The Gas Leak Act, both under Section 3 and 4. Section 3, government took over the right and acted exclusively as in a parent's patriot capacity. So having kept aside the victims from being party to the proceedings, and which also received its affirmance in the two judgments. Now, Section 3, which is available at the same volume 1 at page 176 of respondent's compilation. Because if throughout these proceedings, Union of India alone was permitted to represent the interests of the victims, it shall continue to do so as long as Union of India is able to present an arguable case that the settlement needs a reconsideration. And that flows from the provisions of Section 3, exclusive right to represent, and then Section 4 at page 177. Notwithstanding anything contained in Section 3 in representing and acting in place of any person in relation to any claim, the central government shall have due regard to any matter which such person may refer to the urge with respect to his claim. So this, the central government, I say with respect, can do suo motu because it has taken over the entire responsibility of supervising and ensuring extension of all assistance, including the payment of compensation. So it can do suo motu and can also receive any information or representation which can persuade the Union of India to act in terms of Section 4. Therefore, Section 3 and 4 jointly authorize the central government, and that's why I said that these are power coupled with the duties. These are two provisions which must be construed as powers coupled with duties. And that's where I draw a parallel with the NCW judgment. Yes. Yes. And also, this. In our, there are 3 volumes of judgments compilation which they placed before the court. I'll just indicate, and they also set out the subject matter of those judgments. Volume 1 to know about curative and review powers. There are about 7, 8, 9 judgments there. This in the index, it's the citations and the paragraph numbers. Volume 1, you will also see that. The second volume is on reopening of settlements, very 3, 4 judgments. And the third, in the same volume, I have placed on the third the principle of continuing wrongs and liability for continuing wrongs. And also some judgments on tracing and restitution, etc. In the third volume, we have this duty to do complete justice, judicious remedium, which the Bandhu Mukti Mocha case has dealt with. And we also placed and recorded a judgment in 2016 on the power coupled with the duty, where the court looks at a series of cases from 1952 SCR, Commissioner of Police versus Godandas Banji, 135, which looked at another old English case, Julius versus Bishop of Oxford, power coupled with duty. I'll place some of the judgments. No? There-
Yes, what do you want to say?
There are submissions. One, Martin one prepared on some aspect. I have another set of submissions which actual submissions by Attorney General. So let me read some parts of the learned ASC's note and then switch on to my note. So we have this at page 1. It says, Paul Smiley.
Yes.
Within the parameters of curative petition laid on by so and so, judgment provides for broad parameters, exercise inherent power to reconsider judgments. We give it?
No, non-inadequacy of
Yeah.
presentation,
So we can have it.
reparation under intern.
So which note you are reading out of the two?
No, yeah, maintainability.
You're reading the maintainability one first.
My note deals with certain other aspects as well. Para 1, it says the judgment provides broad parameters and the Honorable Supreme Court makes the inherent power to reconsider judgment. Relates to the rarest of the rare cases where reconsideration of a final judgment is required to set right in miscarriage of justice, prevent abuse of process, obligatory both legally and morally to rectify the error, duty to do justice prevails over the policy of certainty of judgment, declining to reconsider would be oppressive to judicial conscience and cause perpetration of irremediable justice. Neither advisable nor possible to enumerate all grounds on which a petition may be entertained. That's very important. And ex officio justicia, he establishes violations of the principles of natural lordship of that paragraph. And next, paragraph 4, where it talks about the most devastating human tragedy caused by an environmental disaster. That's why it's the rarest of rare cases. And keeping in mind, I'm trying to, again, thinking aloud, why do we say it's one of the rarest of rare cases, which and the Hura judgment, for all its deepest bestowal of consideration to situations which may confront the court in doing complete justice in a given cause or a matter. Cause or a matter, what Article 142 talks about. So the court has bestowed the attention and said, these are very obvious reasons why, after a review, there could still be a lingering reason which may persuade the court to continue to do justice. In the very nature of things, I suppose the Hura judgment was advisably said that these are not exhaustive of the possibility of any other very appealing reason which may persuade the court to add on to the list of categories.
So now you are saying by this note that Hura, which itself was an exception, should be expanded.
Time, while certainly expressing the need for having a settlement as the only good solution beyond that. That's why the finality was never drawn.
We've repeated ad nauseum. How can they finality when there was no trial? You chose not to have a trial. in your wisdom, and rightly so, you
That's
chose
why
not
I
to have a
don't-
trial.
That's
Now you want to say, well, a trial, we didn't go for a trial because it would have been a very prolonged affair.
That's
We
why
took a conscious decision. Now you're going on the premise that trial should have been held.
I'm not inventing any new propositions. The para 214 which I read out, court said I'm rejecting the contention that the withdrawal of the cases from a suit or Supreme Court is illegal. The court rejects that contention. And why are we doing that? We are doing it in Article 140. Therefore, the suit no longer survives. All those proceedings which went
Did you
on.
want the suit to continue? You were the
I know.
instigator of the suit.
Therefore,
You
it's one of those rarest of the rare cases where Lords may find value in that statement or not. The rarest of the rare cases where, without being relegated to those proceedings, since the proceedings are in before this court, continue to be before this court. So what this court can do, treating it the rarest of the rare cases, falling within the hurrah domain, and so by
What is the rarest of
stating
the
a few additional
you yourself rightly said, class action suits, a lot of them get settled. Many of them get settled. We've not had, tort law has not been one of the areas where law has been greatly invoked in India. This was one of the few cases where it got invoked. Class action suit was filed. It was settled in the manner where the US courts, which have possibly the maximum amount of such claims, get settled. Most of them get settled through a negotiated settlement, which is what was done here.
how do your lordship?
Paragraph 188 says in review that there is no judicial determination on the question whether the company was liable. Now, assuming that we accept your all arguments, first thing we'll have to undertake exercise in this curative petition is to decide whether they were liable. Liable to pay compensation, because that's the observation in paragraph 188. So there is no adjudication on that question. So can that be done in a curative petition to go into the question of
We are no longer, that question of liability is no longer a matter at large.
Why?
In a sense, because that's why it's no longer a matter at large. They bought peace by getting us entering into a settlement.
This is a self-defeating
And
argument, attorney. You say we filed the suit.
the
they
question
bought
of
peace.
liability.
Supreme Court says, well, without going into this issue, it is being
Nee,
determined. Now you say there's a quietus to this issue because liability is presumed. Now,
Liability is not only presumed because
yes,
it has been a concluded state of things, namely that you went to the US courts and said you will not
where
adjudicate
is
the
there,
proceedings.
after the observations in the review petition, where is there a conclusion post any adjudication of evidence that they are liable? Please tell us. Let's not act on presumptions.
No, not on a presumption. The whole issue of jurisdiction has been canvassed.
So jurisdiction, you may be right there.
Correct.
That
Jurisdiction
accepted
is something
jurisdiction.
else.
but the
Liability is something
No,
else.
that's
liability,
liability.
liability is something
For the
different.
liability.
Jurisdiction, you are right.
Correct. Suppose the liability part of it. If I'm trying to persuade, please read as many ways as possible into the review judgment and the earlier order passed in May 1989, which said, please read into the settlement and find out if at some point of time or sunshine is stopped, then the liability question will be revisited.
Mr.
Now, this is one
Attorney
of the extraordinary cases in very, very peculiar circumstances.
Mr. Attorney General, the question put is slightly different. You're right, as far as jurisdiction is concerned, after the judgment, the jurisdiction of the Indian courts is accepted.
Right.
Probably the argument to the contrary may not be acceptable.
I can challenge you.
Now, as far as quantum of compensation or the liability, or first liability and quantum of compensation is concerned, it's always open to the parties to say, I want to enter into a settlement, get rid of the litigation. And therefore, I agree without going into the question, either on my liability or the quantum of compensation, I'll pay so much.
Right.
So that's their stand. That we as a package agreed to this. And there are two judgments now, both of the first and the second judgment, the review judgment, which says yes. And the judgment, while the court agreeing why they accepted the package, they've given their reasons. And in the second judgment, as far as criminal liability is concerned, they said no, criminal liability will continue. So that aspect. So that's the argument. Now, what you are trying to do is, you're going to say is, please modify that settlement package. Can that be done unilaterally?
Unilaterally,
And
In
if
that
we want
sense,
to do it, then we'll have to upset the whole settlement.
that's my endeavor is to say no, that need not be done. Except what's being put to me is look at a possible
No, there, if that happens,
a defense.
look, let's assume, let me put it very clear.
Your Lordship.
I think almost as far as liability is concerned, it will be very difficult for them to say that they are not going to. But as the quantum of compensation is concerned, they may have a lot of defenses. They may have a lot of issues in that. You can't say that you will have a free ride.
Liability, the court has observed. The court deciding said that because the occasion to determine the liability, the extent of liability, the extent of causa, nothing arose.
Your Lordship, I'll try
Both
to find
sides
out
took
if
a-
there is a way
both-
out
both-
of looking at that.
No, both sides
I understand.
took a conscious decision. We can't foreclose. I mean, we can't draw presumptions from their thought process and say, why did they settle? So if they settle, they must have known they have to pay. Because they knew they must have to pay, so they must have paid according to this. Now we find they must pay more, so just make them pay more. This is what your argument is coming
No,
from.
no,
It's not a degree, it's a compromise.
of course, although
And there was
all
a,
those fees
there was a
were
memorandum of settlement filed on the record. We don't think it is on the record.
No, 23.3 is.
Order refers to the memorandum of settlement.
it virtually nothing other than what has been reproduced.
Let's assume there's compliance with 23.3.
I certainly, I know since almost since yesterday morning onwards, we are trying to get back to the same question in different forms.
Yes, you are right.
I try to answer
Yes.
one way or the other, and that's because of I thought a very important concern, which if you have very precise formulations of a principle in accordance with relevant legislation, which can be easily stated with some modifications, some amendments, then of course the task is different. But the task is entirely, vastly different here. Therefore, to find some answer to a curative petition with the Union of India says, yes, there are errors which I must own now. Why I must own now? Because we are party to two important procedures. And secondly, the question of the unfolding set of events under the determination sanctioned with the Honorable Court under the Bhopal Catholic Act and the scheme have now thrown much more broader light than what it was in 1991. So, as Union of India, acting under Section 3 and 4 of the Act, can I close to those unfolding set of events and still say, well, court has said you do this or that, and therefore I say I must now no longer call upon the Supreme Court, having acted under 142, to continue to call upon UCC to add an additional dimension of liability. The question, therefore, the Union of India asks, the answer would be no. The court probably should be persuaded to ask UCC to get into that question, because the error which we are trying to point out repeatedly is an error which attaches to the entire process. The entire process is based on certain assumptions, and the assumptions are proved to be erroneous. So if the error continues to be attached to the process, therefore the curative petition, and therefore the question of adding on to the liability will be seen from what the statutory authorities are determined on the application of principles set out in the scheme. Unless the UCC at any point or time said no, when the constitutionality of the act was in question, and this court sanctioned the act and said you go under the scheme, which means anything which could have been determined under the act and the scheme by the process of the statute, the welfare commissioner, was to be something brought up before the court at a later point of time, if, as I said, 3 and 4 persuaded me to bring it before the court. This is what we are trying to do now. So to say that you look at from any other angle, namely what an additional compensation by insurance, or you take it up because it's a parents' welfare state, with great respect, I say they would stop somewhere only when the other questions are
Danny, we are just making it clear that the utmost liberality you'll have to wind up today.
I'm sorry.
At the utmost liberality you'll have to wind up today. There's still 50 minutes, but that's the maximum we can give for this. No one activity. We have to hear. We've said we will not hear the others, but we'll give them a little time to say whatever they have.
We are grateful, my lords. We
We have
extremely
instructed, but still we don't want to shut out anybody. So we'll give you a little time and we have to hear Mr. Salvo. So you will have to at least wind up today.
grateful.
Because tomorrow we'll wind up the case. Well, no, we will go.
That's fine. Section 4. Just maybe a little digression.
Yes.
In the Charanlal Sahu judgment, I just make a note of it. Your Lordships will note that is paragraph 92. The judgment is in volume 2 of the respondent's compilation. Just make a note of it. I'll read it and one is para 92, other para 117. We are talking about the parents patria responsibility of the Union of India, the content of section 3 and 4. In para 117 of the judgment, well, affirming this act, the court said that these are the concerns which you will keep in mind. Section 4, due regard, proper representation, and not slipping into any lapses on the part of effective representation and all that. ensure that no harm results and so on. Enterprise is held to an obligation to provide as it is, so on and so forth. Then paragraph 92. It is urged before us that there was an absolute and strict liability for the enterprise just carrying on the agent of the operation with cases in this country. Further submitted that there is evidence and records that sufficient care and attention had not been given to safeguard against the dangers of leakage and protection in case of leakage. Indeed, the criminal prosecutions that are launched against the chairman and others as indicated before charged them along with the defendant in the suit with the delinquency in these matters and criminal negligence in conducting the toxic gas operation. So, as in the instant adjudication, this court is not concerned with the determination of the actual extent of liability. We proceed on the basis of the law and engage with the court in MC Mehta. Is a decision upon the basis of what damages will be payable to the victim in this case. But the practical question arises, what is the extent actually payable and how will be so and so. Connection referred to the order passed with this court on May 4, 1989, giving the reason why the settlement arrived at figure indicated. So the whole thing is set out here again. This constitution bench also looks at paragraph that May 4, 1918 an order. And that's how ultimately when they say in para 93, 92 end that the deprivation or curtailment, the rights of within the page 348, the last part of para 92. That's one of the reasons why the act was sustained. And 94, one more observation which talks about why the history of this case shall not go in vain. And please also turn over to paragraph 97 in the next page, talking about section 3 and 4. Line about 5. The expression exclusive is explicit and significant. Exclusivity cannot be whittled down or watered down, must be given its full meaning and extent. Corroborated with the use of expression claim for all purposes. Duality of rights is given to the central government along with victims also. The enforcement of the claims arising in the Bhopal gas disaster. It amounts to be so cumbersome, it will not be speedy, effective, and equitable. Not be more best or more advantageous for securing the claims of the leakage. Therefore, I would urge the court that section 3 and 4 call upon Union of India to repeat again that a duty must be discharged because I was trying to place with the Lordship that while both the judgments have looked at the history of the settlement and why it is germane and relevant, just want to keep these 2 pages flat to show that the genesis was from the District Court of Bhopal and how we travel all along. Therefore, the proposal dimension being present right from the institution of proceeding, and Union of India was certainly not averse to it, having regard to the immediacy of the succor to be provided to the victims. So this is at page 390. The whole order has a caption at page 391 called Proposal from the Court to the Parties for Reconciliation, Substantial Interim Relief that has system. That's how it reads. Just make a note of paragraph 6 at page 393. Paragraph 6 and I do want to say this is that since right from the inception of the proceeding, the judicial role played has been exemplary in one sense that immediate succor, immediate justice. So it originated and then, fortunately, UCC, whatever
Always.
the parties in this.
It is always so. In all these
So they have
national
court-
suits, you need succor then and there. What's the point? Otherwise, the legal heirs will benefit.
Why I go back to it is that the rationale.
Frankly, I'm not able to find any doubt on the manner in which the settlements took place or the initiative of the government or the stepping into the shoes of those people who would not be able to prosecute, the role of the court, sometimes pushing them to make sure that a reasonable settlement at that time came through. All this has played a role because it was one factor known was that the assets within the country were a smaller fraction of the total amount which has ultimately been paid. If you take up everything which they had, you still would have got a fraction of it. Now, as and when you got a decree, as and when, that's why the discussion on that. As and when you got the decree, as and when you got the finality to the decree, as and when that finality would go to the US courts for enforcement because the claim there would not be satisfied,
Right.
are all factors which weighed with everybody. We can't say now that we got the money, remove those factors.
No, that's not. I think how I
No, you are putting
frame the phone. My
your arguments, as I've understood in the latter part of almost 7 hours between yesterday and today, is that there were some facts which were not known as how they would unfold. And those facts having unfolded in a particular manner,
Right.
that's good enough ground to fasten them with liability for additional liability, but don't reopen the settlement because that's the settlement under which we are beneficiaries.
Right.
This is, as I understand the broad, and don't go on technicalities, whether it's security, whether it's something else. But since it arose out of incident of this nature, ignore all those niceties and fasten some additional amounts on them as per the code. This is some and substance of what you're saying. Anything else?
तो इनके पास 10 स्टोरी की बिल्डिंग है, फाउंडेशन को वही बनाना चाहते हैं, 5 फ्लोर ऊपर और चढ़ानी है, वो करना है।
Yours is just built up
वो
by
FAR नहीं मिला है।
sufficient.
Anything else which you specifically want to say in the point?
And
You've understood.
Royal
see,
Lordship's
attorney,
attention.
there is no doubt in our mind, at least what you are canvassing. Whatever way we go, they don't go there. But certainly there's no doubt in our mind as to what you are seeking to canvass. To that extent, you have succeeded. You have put forth your point of view as constructors. We understand the point of view. Maybe I've tried to abridge it, having heard you over a period of time, as to what the line of direction is. Because the moment you get into technicalities, you are in difficulty. That's the fact. You are saying take a very larger view of the canvas and try how to further emulate the people who have been identified as it. Looking to the nature of litigation, nature of play.
That's why every time a new issue which doesn't have a precedent confronts the court and says, yes, we sit back in the chair and see how do you provide an answer to this question. It's like looking at the rough edges of a diamond and making it a good diamond. Therefore, this is a case one where some rough edges are there. And therefore, if I have to handle a diamond, I have no problem. But the rough edges of the diamond are there. And that's why we're trying to say this is
and it should be done in a manner the diamond doesn't disappear. Yes, that's all.
Let me just quickly go through my note and I'll try to conclude. And in my note, I've also given references to.
Yes, which is the note you are referring to now?
Submissions, there's a separate note given.
Submissions by the attorney.
That's right. Just quickly run through it.
Yes.
Some maybe little will not feel bad with me for that. I begin. One. This is some very interesting quotes which I thought I can place it to just put it in perspective. Whitehead was an American philosopher contemporary of Bertrand Russell. And this quote comes from his book called Process and Reality. And Bergson, of course, a French philosopher. And
I tell you one factual aspect. Yeah. After review judgment, there are fresh claims filed.
Claims have been filed even today. Okay. As far as claims,
so there are substantial number of claims were filed even after review.
There are two sets of claims. One, those who fall within this 5.74. That is the final number. But within that, there are claims which keep coming up regarding the so-called.
So there were fresh claims filed even after review. Review was decided.
Yes, yes.
Very large.
After review.
Mr. Suka asked more than once. Is this 675 paid or is it to be paid? There is an affidavit filed by the union. Not that this is their case is not that there is any amount remaining to be paid for which they need money. Their case is compare the assumptions of 1989 with the actuals and revise the settlement. They gave figures of what they have paid. My lord asked so two figures yesterday, 1548 and 1509. What is 1548? They have explained 1548, madam, in an affidavit. And in that affidavit, your lordship will see the figures, including this pumped up figure of the revised figure from 20,000 to 521,000, were all paid. And it came to 1548 when they came to your lordship. Now, if your lordship sees in the curative page 329, P7. So at least let the factual position be here of nothing is to be paid.
The second volume of Priority.
The NGOs are saying the government should pay us more, to which the government is saying we owe you nothing more. I'll show that. Please see.
That I've given that, sorry,
Just one.
the note.
See P7.
Salve, you pointed out it now.
Very good.
Within the note which I've given, there is a reference to it. I'll come with a certain footnote so that this clarification is made.
No, in this, Mr. Salve said you are saying that you don't have to pay any
Total amount that we,
So the NGOs are claiming amount.
whatever received amount has been paid.
Is it your say that you are liable to pay more to the
That's right.
NGOs?
Would your lordship just see the one page so that
Not,
you're
we are
clear?
not liable. The UCC is that person.
No, you are liable.
Page number?
320.
Whether you recover from
Volume
different matter.
security petition.
Therefore, I put it directly to you. As a government, as a welfare state, as something else, are you liable? You say, I want to recover from carbide. That I understand. No difficulty.
That's a table.
Then we will note that the government wants to pay more. But the government doesn't want to pay more.
PC page 329, P7.
The
329, P7.
chart.
Yes. And I will marry these figures, compare them with the security petition, which, and the attorneys note, unclaimed one, claim 2, 3 months. Different. And restoration and data.
There is a problem.
Look at P7. Number of cases, death 5295, same as present.
Yes.
See page 320.
Since you want me to conclude today, let me.
Yeah, Mr. Sabe, I want him to.
Yeah, otherwise,
Correct.
I will run through tomorrow.
Yes. We don't want you to do that. Certainly.
That's a threat Mr. Salve has said now.
No, I am only asked you a question.
I'll
You,
come with a-
according to you, more amount is to be paid because see, there will be an issue which will crop up by reason of the requirement for you to take out insurance policy in the manner provided after the curative petition has been done. So the manner of paying additional amounts or may be required to be paid for these NGOs, are you saying you are willing to accept the liability if you
Not
find in your favor?
I have no connection. We are not answering to any. I'm talking.
It's very easy to dip into somebody else's pocket and take out the money. Question is, are you willing to dip
You're
into your own pocket and give it the money?
I would probably.
Then see whether you can dip into their pocket or not.
I'll answer that also.
Yes.
Very.
Yes, please.
A capital para A.
Yes.
Your lordship will read the quotes you own and read through them.
Yeah.
But Bergson I thought very interesting. But it says in order to think change and to see it, the whole field of physical progression, right? Some of them artificial, created by philosophical speculation, the others natural to common sense. Now let me see. The curative petition has been filed by the Union of India as a parents' patria of victims of the world's largest industrial disaster, seeking enhancement of compensation in the settlement. Submitted the fundamental lack of completeness of fact touching upon the quantum of liability of Union Carbide Corporation. Consequently, the quantum of damages payable have initiated the settlement, affirmed with the Honorable Court in the order dated so and so, and judgment dated so and so. Both in the first settlement judgment and the review judgment, is Honorable Court underscored the possibility for a second look at a settlement and the need that may arise to do so. The fallibility of endorsing the settlement without leaving room for reconsideration has informed the Honorable Court in holding so. Position taken in the Honorable Court has been always a room for a second look is also in tune with instances in other jurisdictions. The courts have been very slow in giving their final stamp of approval to settlement or compromises in such class of cases. That's the US Supreme Court judgment. The Honorable Court will approving the settlement that observed that the same was not final, was based on certain assumptions of truth, and the said assumptions are unrelated to reality. The elements of justice of the settlement will seriously be impacted. following observations on the Supreme Court judgment, the settlement judgment is significant. These are broad and general assumptions underlying the concept of justness of the determination of the condition. The total number of cases of death or of permanent, total, or partial disability, or what we call catastrophic injuries, is shown to be so large. The basic assumptions underlying the settlement becomes only unrelated to the reality. The element of justness, the determination that have truth of its factual foundation would seriously be impaired. The justness of the settlement is based on the question of truth. Indeed, different opinion, the interpretation of law and questions of policy, or even what we consider wise or unwise, but one speaks of justice and truth. These words.
But on these categories, attorney, nothing on these categories, the amounts have been lesser. People have been lesser. The expanded category, therefore, we began that yesterday, was that the expanded category is there where, on account of the incident occurring in that area, you thought it appropriate to give some kind of a solace amount to everybody, because some way or the other it had, would psychologically or otherwise affect people, apart from serious medical issues which have been caused. That's not, if you take out that category, there is no problem in all these cases which you are talking about.
No, then the other category.
Partial disability, serious disability,
They are. That's where we had to step in 2010 and give them
chart. Your chart itself shows, the first chart you gave itself shows the position.
In my notes.
No, that Tony is the right position. In spite, after even including the enhanced compensation, the figures would be within the limit.
Yeah.
Figures would be within the limits. The difficulty has arisen because of the expansion in the category of minor injuries. That's the reason. I've done my.
It would have been less. I mean, it doesn't require too much of mathematics to it.
No.
The fact is, if you take down the first note you gave, the last column, additional requirement required to be paid, some are less, some are more.
Correct.
If you take out this 955
No, that's
crores, then 675 less, you are well within the reach. There is extra money available. It's only on expansion, or therefore we kept on saying it's an expansion of the claims of minor injuries that all this has occurred.
I've not read the entire note because there are subsequent.
I'm saying the portion you are citing will not apply.
No,
Because the portion you are citing applies to in the unforeseen eventuality of a very large number of serious cases being detected. That's not what has happened.
No, if you also look at the subsequent pages of this note, which explain the reasons why the claim 1, claim 2, and claim 3 in the curative petition are sought to be explained in the subsequent pages of the note.
Yes.
Page
even in yesterday's note and today's note, there is a discrepancy. Yesterday's note, you say that actual number of cases of temporary disability were 35,455. And the note which you are reading on page 7, clause B at the bottom is 3434. Today's note, page 7, paragraph 13B. Actual figure of temporary disability is 34,343. And yesterday's note contains the same figure as 35,455. 1,000 more. We don't know what is the correct figure.
In the note which had
Today's note,
that's right. That's page. This what I have done is for page 5 of this note. These are updated up to 2022. That's why I sought your lordship's permission to
So,
update.
as far as this temporary disability is concerned, how many are there? Total number of cases 35,455 or 34,343? Because with each case 50,000.
It is 34,340.
So yesterday's figure was not correct.
That's right. At page 5.
Not correct.
Even between 2010 and 2022, this difference is there. And that's why I put the updated figure. In some cases, the number has gone down, in some cases gone up. So that's why these updated figures, I think, are important for the purpose of taking a bird's eye view of current situation. Then paragraph 7 of my submission, the earlier paragraphs all deal with what has been stated in the review judgment and the settlement judgment. If all the essential facts relating to the number of deaths and the nature of medical afflictions have been present before the honorable court, it can be said with certainty that the quantum of settlement would not have been what it was, even though it could be said to be hypothetical. But due to fundamental errors in the determination of even the ad hoc settlement upon principles of expeditious resolution of the agonizing claims of the Bhopal victims, stated the tortfeasor retained an unquantified sum of money to be to the detriment and loss of the gas of treated population. The retention of such quantum of money, which would have otherwise been shared with the victims, can be said to be akin to unjust enrichment, submitted that in all such circumstances where the quantification of damages, compensation through a process of settlement or otherwise exposed to legitimate challenges, the principle of unjust enrichment, the need to dislodge its benefit, and the person or entity was retained as a result of such errors or otherwise, can be located in an amalgam of merger of 1, the right to remedy, access to justice and fairness of outcomes, all of which are now constitutionally guaranteed. The judgment of the Honorable Court in Indian Council for Environmental Legal Action endorses the affirmative duty of the court to undo such retention of benefit in dealing with all instances of unjust enrichment and understanding a wide comprehension of the principle of unjust enrichment. The Honorable Court will pursue to also, after paying attention to the aspect of the finality of the judgment in paragraphs 103 to 140 thereof. Then para 8 looks at Permanent Court of International Justice judgment and on the question of reparation. What do you mean by reparation? Just a few sentences there. The essential principle contained in the actual notion of an illegal act, a principle which seems to be established by international practice, in particular arbitral tribunals, that reparation must, as far as possible, wipe out all the consequences of the illegal act and re-establish the situation which would, in all probability, have existed if that act had not been committed. And that's the principle. Now, paragraph 9, I said the observations of a review judgment can be legitimately construed and let us keeping open the need for subsequent process reviews. Regardless of the conclusion of the settlement judgment in answering question J, and the imposition of certain obligations to the Union of India to fill certain gaps in the quantum of compensation submitted as what's being canvassed is the Honorable Court on updated facts and circumstances is a continuation of the review process. The curative petition therefore deserves to be treated as a necessary, essential, and indispensable recourse to justice. To underline, I say it's a continuation of the review process and not a initiation of a fresh, independent process. Therefore, that's why I said the Huda judgment may have to be endorsed in an additional way. And this would probably be the better way of going about it. Then paragraph 11, in held a rubric of immediate evidence that where there is no precedent, establishment of precedent will lead to multiplicity of actions. It is held if men will multiply injuries, actions must be multiplied too. For every man that they do ought to have its recompense. Then in page 10, there are two other dimensions I thought you will also look at it. Page 9, what para 21. MIC Gas Lake, even an act of negligence and breach of the obligation of the duty of care and the duty not to act negligently. Having breached the duty of care and be responsible for MIC Gas Leak as an act of negligence, UCIL was under further obligation to do all things and take measures to rectify the consequences and impact of the act of negligence. The settlement entered into between UCC as the parent company, so and so, the reason of the majority shareholding and other factors related to the commissioning of the plan, operation control, and Union of India cannot be construed as effective and final the quantum of compensation. The bargain of settlement for an inadequate quantum is seen as an attempt to bring to a close prematurely all liabilities relating to compensation. If only a fair and final closure in the issue of quantum of compensation can be said to be relieving from the subject of liability. As long as such a fair and final closure has not occurred, it can be stated that UCC continues to be in wrong, in not effectively, and finally rectifying the consequences and the impact of its negligence. Therefore, UCC was not only in breach of his duty of care obligation, but also in breach of his obligation to rectify the impact of his act of negligence. This twin breach of obligation is a continuing wrong. That there is a need for a further extension of the principle of habeas corpus. The concept of continuing wrong or continuing injury is a matter of procedure falling in the domain of limitation of action. These are statutory prescriptions. Even in the matter of application of continuing wrong or continuing injury, courts have felt the necessity of having a flexible approach. As long as it shows that the wrong continues to have a non-abating effect on impact on life and physical well-being, the court will lean in favor of an expansive application of the continuing wrong principle to do complete justice. This is a case of both a continuing injury and therefore a continuing wrong, as also a case of continuing right. It is well settled that where wrongful act is of such character, the injury caused by it continues, then the act constitutes a continuing wrong, well stated in 1959 Supreme Court. Is then para C, the settlement can be reviewed by the Honorable Court. Paragraph 24. The settlement judgment is also the review judgment to align the uncertainty of fact relating to the number of deaths, nature of injuries, and the increasing number of people affected both by patent and latent impact due to exposure to methyl isocyanate. The uncertainties expressed in these judgments reflect the state of uncertainty that prevailed in similar mass tort situations. The asbestos-related litigation was England, the United States of America. But over a long period of time is a classic example of the limitations that claimants, courts, governments, and scientific experts are faced in such situations. In view of this, no part of the judicial process can have a dimension of estoppel that it would shut out our examination of due and just claims. The fundamental right of acts of justice must prevail over all of the technical and procedural dimensions of administration of justice. So, para 26, there is a reference to this because in the counter affidavit and their written summary, they talk about two judgments, 2007 and 2011. I would like to look at it like this. The unfolding sets of events placed and occurred in the curative petition. The two applications dealt with in Bhopal gas periods also in 2007-9 SEC. The intervention applications filed by parties in the curative petition added petitions also. And the proceeding time taken by the Welfare Commissioner. Together demonstrate beyond any doubt that the facts and figures reckoned for the purpose of the settlement are not sacrosanct and are no longer final and govern such matters. Then paragraphs 28 to 30, I looked at some of those practice of settlement procedures in the US courts. May just look at that. I don't want to read it in pencil. Then, heading D, I try to look at how UCC will bear continuing liability. That's notwithstanding all the internal corporate agreements they have made. Look, one submission in the context of paragraph 35, 13. Bandhu Mukti Morcha Lordship said, look at 32. What is the scope of adjudication powers in 32? It's worth looking at what the Lord said in Bandhu Mukti Morcha and the scope of Article 32. Now, why I'm talking about it is not a 32 proceeding, but since the court has withdrawn everything at 142. Being a final court, everything is in the hands of this court. So, paragraph E, so I thought I'd bring to the international position on liabilities. So, given the scope of the global expansion of trade and commerce and the possible impact on human rights violations, certain international principles towards imposing obligations and liabilities on corporate and trading entities have been involved. The UN Guiding Principles on Business and Human Rights set out the following principles relevant on reliance can be paid. I quote, these guiding principles are grounded in recognition. One, states' existing obligation to respect, to protect, and fulfill human rights and fundamental freedom. The role of business enterprises and specialized organs of society performing specialized functions required to comply with all applicable laws in respect to human rights. The need for rights and obligations to be matched to appropriate and effective remedies and treatment. These guiding principles apply to all states and to all business enterprises, both transnational and others, regardless of their size, sector, location, ownership, and structure. The guiding principles should be understood as a coherent whole and should be read individually and collectively in terms of the objective of enhancing standards and practice with regard to business and human rights to achieve tangible results for affected individuals and community, thereby contribute to socially sustainable globalization. So similarly, the OECD guidelines for multinational enterprises also provide principles toward responsible business conduct in a global context. Then paragraph 1, they respect human rights to avoid infringing on the human rights of others and address adverse human rights impact involved within the context of their own activities, avoid causing contributing to adverse human rights impact and adverse such impacts. Then seek ways to prevent and mitigate adverse human rights impacts that are directly linked to their business operation, products or services by business relationship, or even they do not contribute to those impacts. So I just placed them on record only to say that at the international level, you have these issues, international commerce and trade and impact on human rights, has received attention. I remember when, in the context of a termination for health treatment, the local hospital in England, Cambridge State Authority, Reliance was placed in Article 10 of the European Convention. And the submission was that, of course, it could not apply directly. That's before the 1998 Human Rights Act. I remember it was a judgment by Ross J. who said these are persuasive principles of public policy and so internationally recognized. For the persuasive principles of public policy, which your Lordship noticed in Vishaka and a large number of judgments later. So, business enterprise obligation, states' right obligation to protect human rights violations and to seek that there is an effective remedy and their redress. Your Lordship also make a note in volume 1 of my compilation. There are two. Okay. Made other that there are compilations on.
Now, which is this another?
I'm not going to read that. I want to.
No, of course that. But what is the compilation?
Compilation certain articles and extracts from books, but I Lords will just pick up volume 1 of this compilation on the meaning and definition of fraud and mistake. That's just make a note of it in volume 1. Serial numbers 4 and 5. Serial numbers 4 and 5, volume 1. I don't propose to read it.
Thank you. Our journal, the last 2 days for 7.25 hours. And yes, tomorrow.
Reply first.
So we give
Hello.
10 minutes each to both this, both of them.
More than 10 minutes.
Sorry, we are not willing to hear you. Either you can compress it in 10 minutes or you can't. Whichever way you want.
Not also one request.
Yes.
Papers are still not on record.
Which one?
My lords, we will attempt to satisfy, my lords, that a para of the relevant order was not read out. That was
Do
not,
that. Do that.
tomorrow we'll do that, my lords.
But I was only saying, your lordship will hear them, no problem. Not papers.
See the last order.
Yeah, exactly. So when I'm worried at what the attorney has filed. Now, it shouldn't be, the attorney's file not be there.
And what we have filed.
What we have said, we are not, since they are here for 2 days, we give them each 10 minutes to say what they want to say broadly. Attorney has to address, he has addressed.
Not so.
Thank you.
Get to
ये कर भेज दीजिए
Should I say?
नहीं इतनी भेजिए बस बाकी है ना